dispose of.
No, so-
Same order may be passed by law.
No.
No, is it?
No.
Then 16. Otherwise, petition is bad, my lord. My lord.
देखिए, it will come in the usual course.
2016, my lord.
Here, fish my lord. Petition is a lady my lord. 3 months baby is there. Finally transfer case my lord. Before vacation, I have filed the case my lord.
Pardon, my lord, this is a second appeal, order 41, rule 11, my lord. Now the civil court is proceeding with the execution case. My lord. Here is a two second appeal.
Number 4. Anganwadi worker selection matter. Petition is though is selected, but due to pending of the debt petition could not be joined in this case, my lord. Before vacation, I will file the memo.
Anything else?
Pardon, my lord, tied up bail application, my lord.
Yes.
Tied up in bail application, my lord.
Tied up bail application as with your.
Your lordship fixed to their May, my lord. They are not
Zero to again there.
My lord, another second appeal.
No.
Item number 6, my lord. Conducting counsel is suffering from
Just a moment. Out of list.
Pardon to mention, my lord.
Second appeal, my lord. There is a stay against us, like to mention,
Of which year?
of 2022. Sir.
No urgency.
May pardon to mention, my lord. Able tied up matter, my lord. And another, my lord, withdrawal.
No, only one. Withdrawal টা Withdrawal.
My lord, in another matter, there is an injection against us.
No.
The second
Yes.
Item number 6, my lord.
Item number 6 of which list?
TRPC.
Of which list?
Today.
Supplementary list.
Supplementary list. Conducting counsel is suffering from knee injury. 1 week time.
Please this matter next week as paid for.
My lord.
Bless.
My lord, item number 15 of the supplementary list on behalf of Sashwati Mahapatra, I sees not well to kindly adjourn the matter to next Monday.
Not next Monday, next week it will come. Please this matter next week as paid for.
Obliged.
Supplementary list, item number 1, fresh admission.
Yes, may I please your lordship. The petitioner is seeking transfer of a criminal proceeding pending before the Land and Family Judge Keonjhar to the court of the Judge Family Court, Cuttack, my lord. In this aforesaid case, my lord, the petitioner is the husband. Prior to this, the petitioner has filed a case under section 9 before the Family Judge Cuttack, which was transferred to the court of the Judge Family Court, Keonjhar. And in that case, direction was given to the petitioner to move before the Judge Family Court for virtual mode, my lord. So I pray before your lordship, the petitioner may kindly be given liberty to request the Judge Family Court for virtual mode. So
Yes.
appear.
Prayer for transfer of CRLP number 108 of 2023 pending in the court of learned judge Family Court at Keonjhar to the court of Judge Family Court, Cuttack, has been made in this application. The petitioner is the husband. The proceeding in question has been filed by the opposite party number 1.
Miller. Only
By the opposite party number 1 though?
Miller.
Opposite party number 1. What is that proceeding?
That is 125 CRPC, Miller.
Under section 125 of CRPC. Stop. Considering the grounds cited, this court is not inclined to grant the prayer of transfer, to prayer for transfer of the proceeding. More so, as the petitioner can always appear through virtual mode by seeking necessary permission of the court below. By seeking necessary permission of the concerned court. The transfer application is therefore dismissed. However, liberty is granted to the petitioner to move the concerned court seeking permission to appear through virtual mode. Stop. If such application is moved, the same shall be considered by the court below in accordance with law. Stop. Further, the personal attendance of the parties shall not be insisted upon unless absolutely necessary.
Oblige.
Item number 2. Item number 2, my lord, I am in VC, my lord.
Yes, item 2.
My lord, I am in VC, my lord.
Yes.
My lord, the petition under section 125 CRPC is pending before the Lord in STGM Chhatrapur.
Yes.
I am for the husband opposite party.
there is life threatening to appear before the Chhatrapur as the residents, the petition, the opposite parties' families are powerful persons. So I have filed a petition to transfer to Learning Judge Family Court, Cuttack.
No. No. If you are apprehending life threat, then you can always seek police protection. You can approach the court below. That is not a ground for transfer.
If Lordship will allow me to appear in virtually, if liberty may be granted.
Considering the grounds cited for transfer, this court is not inclined to entertain the application. Stop. The transfer application is therefore dismissed. It shall be open to the petitioner to seek permission of the court to appear through virtual mode. Stop. That's all. Yes.
Item number 3.
Please, your lordship. Sir,
What is
petition
the
is,
change of nomenclature?
yes, sir.
Yes.
Sir, petitioner is the wife, sir.
What is the change of nomenclature?
Sir, TRPC is C, sir. Sir, matter case number 45/23 এটা সিভিল জজ 8 গোটা ଅଛି সেটা जोटा कि मु TRPC CRL कर देछि सर এটা C हपा कथा सर
नहीं तब तो चेंज हो ना नंबर टा चेंज हो ना नंबर भी चेंज हो से सेमती होबनी खाली सेटा चेंज कर देल होबनी ये TRP CRL अनुसार नंबर होइछि सेटा TRPC अनुसार नंबर होबो सो let us say it is the office has to change it considering the submissions they pray for IRA हैला therefore change of nomenclature is allowed.
सर आईएर रे स्टे गोटे फाइल करछि सर प्रोसीड
कौन करे it has to be registered na office is directed to register the application as CRP हैला release this matter on Monday. Yes.
ओले सर
Item number 4.
May I please? Petition seeking direction for the transfer of the criminal proceeding lordship, JMFC of Bhubaneswar to Puri lordship.
I don't know. TRPC release this matter. Yes.
Lord and JMFC of Bhubaneswar to ADGM Puri lordship.
Yes.
Petitioner is a old man and a cancer patient lordships. Only charge sheet is filed in 2023. Offense 420, 294, 5
He is accused.
No, my lord.
Is the informant.
My lord.
No.
Old man cancer patient.
Informant कौन जाउची इस तरह
प्रत्येक डे टू डे फिक्स रे से अपील करि परन
प्रत्येक डेट रे सीख जा करबी
एंगेज करछि एडवोकेट भी एंगेज कर
ना informant काहे जा
होछि आगो नि proceeding is not
sir why will the informant appear tell me in a case what is the role of the informant in a criminal case very limited apart from giving evidence and maybe giving a note of argument after conclusion of the argument by the public prosecutor. You have nothing, no role to play. The petitioner
3 lakh cheated from the petitioners
who is the informant in GR case number 432 of 2022 pending in the court of learned JMFC bracket O Bhubaneswar seeks transfer of the said proceeding to the court of learned SDJM Puri. Stop. Since the petitioner is the informant, he is not required to appear on each date of posting of the case. Moreover, his evidence can also be recorded through virtual mode if such a motion is made. Under such circumstances, I am not inclined to entertain the application.
Trial may be expedited.
The transfer application is therefore dismissed. It shall be open to the petitioner to move the court below to seek permission to appear through virtual mode whenever necessary.
One trial may be expedited.
No.
Item number 5.
May I begin to please your lordship, my lord. Petitioner is the wife and the opposite party is the husband. Husband has filed a divorce proceeding in the court of Hon'Ble Judge Family Court, Cuttack, my lord. Petitioner has filed this case to transfer the CP 6930 over 2023 from the court of Hon'Ble Judge Family Court to the court of Hon'Ble Judge Family Court, Kendrapara. If I accept this proceeding, my lord, the petitioner has filed a criminal proceeding under section 125.
Take notice. Issue notice. to the opposite party by speed post, fixing a short returnable date. The requisites be filed by tomorrow peremptorily. Place this matter on
11th July.
11 July. Yes.
Item number 7.
Allowed to appear through virtual mode.
Yes.
My lord, so this is a transfer petition filed to transfer a civil suit bearing number 116 of 2011. It is a year-old matter from the court of the senior division, civil judge Padnagar to Balangir. Your lordship.
Why? On what ground?
Because on the ground that the petitioner number 1 and 2, being old aged and ailing persons, could not able to move to Padnagar. They are permanently residing at Balangir at present. And
Sir, please come to your cooperative petitioner number 4. Vikas Chandra Badu, son of Brahmara Badu, age about 59 years. Opposite party number, opposite party number 1 है Dubisai Bibhuti Bhushan Badu, son of late Brahmara Badu. How do you explain this coincidence? The name of the petitioner number 4 and opposite party number 1 are the same. Father's name is the same, except the father of the opposite party number 1 has been cited as a deceased.
Your lordship, inadvertently, in petitioner number 4, the late what has been missed out, your lordship.
So how can the petitioner number 4 also become the opposite party number 1?
No, petitioner number 4 is Vikas Chandra Badu and OP number 1 is Vibhuti Bhushan.
Vibhuti Bhushan Badu. Achha, what about this late Brahmara Badu?
Late Brahmara Badu is the father of the opposite party number 1.
No, eti kichi late lekha alani petition number 4 pakhare.
Petition number said inadvertently that it has been missed out during the typing of this.
So inadvertently, who is going to supply that omission? You have to correct it.
I may be allowed to change.
Yes. Land counsel for the petitioner is permitted to correct the error in the cost title, typographical error in the cost title in court. You have to do it in court. Do you have any associate here?
Yes, your lordship.
All right, then do it in the court. I'll take it up then on Monday. Place this matter on Monday.
Obviously.
Yes.
Item number 8.
May I please, your lordship? Your lordship, present petition is the wife and opposite party is the husband, your lordship. Husband has filed, opposite party has filed restitution of conjugal right petition in his jurisdiction under Jajpur, Family Court Jajpur, your lordship. In the Family Court of Jajpur. The present petitioner is the wife, housewife residing at Cuttack jurisdiction. He has filed the CRPC maintenance case at Family Court Cuttack, your lordship. My humble prayer, kindly transport that CP proceeding to the Cuttack. In the court of family, in the court of Judge Family Court.
All right, issue notice the opposite party by speed post. Fixing a short returnable date, requisites be filed by tomorrow, peremptorily. Place this matter on 11 July.
Oblige, your lordship. High level.
Item number 9.
May I please? When a transfer application is filed on the behest of the wife, my lord, for transfer of the CP case, which was filed for dissolution of marriage by the husband before the Learned Family Court Baleswar to the Learned Civil Judge Senior Division Rajgangpur.
All right, take notice, issue notice the opposite party by speed post. Fixing a short returnable date, requisites be filed by tomorrow peremptorily. Let's this matter on
11th.
Huh?
11th.
I have filed, my lord.
In the meantime, if any application for adjournment is moved on behalf of the petitioner in the court below, the same shall be considered, having due regard to the date of hearing. Date fixed for hearing of this case. Yes.
Item number 10.
May I please, Your Lordship? Here in this case, my lord, the present petitioner pays for engagement of Anganwadi worker in place of her mother, my lord, as her mother was died during her service period, my lord. The mother of the petitioner was engaged as an Anganwadi worker since, my lord, 12/9/2009.
Is it a family business or what? If the mother was working, if the mother dies, there is a vacancy, it will be advertised. How can you be appointed?
My representation, my lord,
What representation?
I consider
No, this is completely illegal. How can the representation be considered?
No, only member of our family Miller.
No, no.
And they were
No.
elected by Gal Miller.
No, there is no such provision. The statute doesn't provide so. And I will direct the collector to consider the representation. Knowing that it is an illegal.
With law in academic Miller in
No. You may. I am giving you a chance to withdraw this writ application. Otherwise, I am going to dismiss it. Permitted to withdraw.
Item number 11.
May I please your lordship? The lordship, this matter is regarding regularization of service of the petitioner who were appointed as a Ganashikyak. And others versus state of Odisha.
Yes. Make necessary corrections in that order again. Have you corrected it?
My lord, already coordinated by this order.
What coordinate bench? I also have orders. Are you not aware?
No, my lord, I am not. Similar.
I think subsequent cases of Mr. Kunal Kumar Swami and
Yes.
associates are there,
Yes.
and they are producing your lordship's order.
Yes.
But the point remains in this case, my lord.
Multiple.
With respect to the single applicant, the lordship, my lord, a such type of order has been passed. But with respect to where the petitioners are more than one, lordship has granted them the
Individual representation.
individual representation, which will be advanced.
Yes.
That is here, my lord. I think that
Four petitions. Yes. You find out that order? Not that. I have my own order. Should I follow any coordinate bench's order? I don't understand. Prepare moto coordinate prepare coordinate siddhi aschinti. Pass over. Get a copy of that order and come. Yes.
Item number 12.
Item 12.
The limited prayer lordship of Anganwadi worker selection matter lordship. The petitioner prefer appeal challenging the engagement of
ticket.
OP7 lordship.
Yes.
And accordingly, the appeal was allowed. The lordship can have a glance on page 13, the ordering portion. The selection committee has been directed to reconsider the candidature of the present petitioner, and if he is suitable, then engage her. And accordingly, page 14 annex 2 lordship. On 26/10/2023, they called me with all documents, lordship. The date was fixed on 3/11/2023. On 3/11/2023,
so no decision has been taken.
Yes, lordship. That is only lordship.
Yes, we'll direct them.
Yes.
The petitioner has approached this court. The petitioner had challenged the selection of the present opposite party number. She must have also challenged that order.
She could challenge करना कि आज बहुत वर्षे हलाने किसी notice हमको आसने किसी.
All right. The petitioner has challenged the order. You must have challenged it. She must have definitely challenged it.
As his submission, your lordship, Sangeeta.
Yes, sir.
7.
The petitioner filed an appeal
Sangeeta
before the ADM. ADM की है? Rayagada.
Yes, sir.
ADM Rayagada. Being Anganwadi appeal number 1 of 2022, challenging the selection of present opposite party number 7, Secretary Sangeeta Kunaka as Anganwadi worker. Said appeal was allowed by order dated 9/5/2023 with direction to the selection committee to convene a review meeting and reassess the suitability of the appellant Lisa Korsika, bracket petitioner, to the post of Anganwadi worker. Of Ghagudimala AWC, taking into consideration the observation made in the order, and if found suitable, to appoint her as such. The order was directed to be complied with. No, the entire process was directed to be completed within 1 month. pursuant to such order, the CDPO, कौन से ना कल्याण सिंहपुर ना कौन से कल्याण सिंहपुर by letter dated 26/10/2023 called upon the petitioner to appear along with her original testimonials. So, कोई दिन appear कर रहे थे ना
3/11/23
on खाली on 3/11/23. It is submitted that the petitioner duly appeared and produced the required documents. It is her grievance that since then no action has been taken in the matter. So, it is further submitted that order of the appellate authority has become final as there has been no further challenge to it.
Submitted.
I have said that. Considering the submissions as above and the limited grievance of the petitioner, comma, the writ application is disposed of, directing the CDPO Kalyan Singhpur to, will it be the CDPO or the
sub collector, the head of the committee?
Directing the sub collector Ragada?
No.
Sub collector Ragada to act upon the directions issued by the appellate authority, comma, if not already acted upon, within as early as possible, preferably within a period of 4 weeks from today.
Okay.
Item number 13. Please, your lords. This case, my lord, petitioners are the villagers. Villagers of Chokko Satho, my lord. Under Chokko Satho Gram Panchayat of Sodar block in the district of Baleswar.
How is it maintainable?
The alleged, my lord, there is corruption, my lord, and there is a misappropriation, my lord.
Mr. Sakpati, it is not maintainable with your experience. You may seek withdrawal with liberty to move the collector. That order can be passed.
Or an FIR can be lodged if there is.
Let them. So that FIR order I will not pass. I will say that they are permitted to withdraw with liberty to move the.
Yes.
Collector may cause inquiry and.
सेवड़ा कोई होगा नहीं maintainable हो बिल्कुल किंतु होगा हमारे PL फाइल कर लेंगे
हाँ सेटा है कल
PL कर दो ना थी
ये lordship pass this order then they have also moved the collector, my lord, and also SP vigilance.
Learned counsel for the petitioner seeks permission to withdraw the writ application with liberty to petitioners को दें है ना petitioners seek नहीं petitioners कौन लिख ले ठीक है सिटी लिखा है seeks permission to withdraw the writ application granting liberty to the petitioners to move the collector Baleswar
Collector district magistrate
collector Baleswar collector Baleswar highlighting their grievances. So, permission is granted with liberty as a person.
I don't know, time may be granted, my lord, may consider and dispose of.
সেটা হলে পুরো রিট পিটিশনটা এন্টারটেইন করা বলে হবনি সেমটা হবনি উইথড্র করার পরে সেটা কেমতে হবো কোন দিকে মেইনটেনেবল হি নো রিট অ্যাপ্লিকেশন আগে আপনার রিপ্রেজেন্টেটিভ ক্যাপাসিটর ফাইল করছেন হাউ ইজ ইট মেইনটেনেবল টেল মি
within a reasonable time, if your lordship not granted some time, not stipulated time, then may dispose of within.
And further, direction to the collector Baleswar to dispose of the representation so filed by the petitioners. The petitioners within 4 weeks from the date of its filing. Yes.
Okay. Item 14.
Please, Lord, Annexure 15 Page 63 is the informed order passed by the collector.
Annexure 16.
Annexure 15, page 63.
Collector ko Anganwadi is appeal sunile. There was a direction
Directed by this honorable court on
Who is challenging this order? What is wrong in it? What is the fact?
The fact is that, my lord, in a due process of selection, the petitioner was selected as Anganwadi worker and he joined in service. While continuing in service in 2014, your lordship will get that.
He na see mo?
See.
No. See no?
Let's see us served with a show cause notice that some irregularity has been committed. Annexure 2. I submitted my reply. But without considering that reply, I was disengaged from service. Challenge is that order of disengagement, I approached this honorable court in the writ petition and your lordship directed to prefer appeal. Accordingly, I file appeal under Annexure 6. In the appeal, my lord, that order was set aside. I was allowed to join in the service. So during pendency of the appeal, another person was appointed.
Vigilant. But that appeal was allowed by which order?
Annexure 9.
Annexure 9. Yes.
Annexure 9, page 41, your lordship. In view of the aforesaid discussion, order dated 22/8/2014 of Sub-Collector Baleswar containing direction to the CDPO Remuna to disengage appellant and consequential letter dated 22nd of August 2014 of the CDPO Remuna to the appellant in engaging her request. Thereafter, I was allowed to join in service. So since the CDPO, as there was bent upon to harass this petitioner, Malapsi did not hand over, he did not direct the other side who was appointed in the meantime during pendency of the appeal to hand over the charge. I again approached the collector. Collector directed the CDPO to take appropriate action. Thereafter, my lord, your lordship will get at Annexure 12, page 45, a direction was issued to the private opposite party to hand over charge to me. So in between challenging that Annexure 12, she filed another petition before this honorable court. And thereafter, I was again disengaged from service under Annexure 13 by order dated 27/2015. Challenging that order, I approached this honorable court. Both the writ petition were had, your lordship will get at the order at Annexure 15. Thereafter, my lord, the appeal which was allowed in my favor, though it was never challenged, but this honorable court was pleased to pass that appellate court order and directed the collector to pass the fresh order. Now the collector has passed just the reverse order what he has passed earlier.
Well, take notice. You will accept notice for all the opposite parties except 7?
7, yes.
Sri S.N. Patnaik, Learned AG, accepts notice on behalf of opposite party numbers 1 to 6. How many copies do you require?
As it has been pointed by my colleague Mr. Hon'Ble, now we are adopting that particular procedure of the LMS.
So you don't need any copy.
Presently,
one extra copy of the writ application be served upon Sri Patnaik by tomorrow. Sri Patnaik submit issue notice to opposite party number 7 by registered post with AD. Returnable within 4 weeks. The requisites be filed within 3 working days. List this matter on
1st August.
1st August. 1st August.
Yes.
Item number 16.
This case, my lord, petitioner was disengaged from service, my lord, on the ground of production of fake certificate, my lord. Yesterday, lordship passed exactly same case, my lord.
Bundelkhand University.
Bundelkhand University.
Yes, yes.
Yesterday
there was a matter.
Yes, my lord.
What order have you?
That is, my lord.
What order was passed yesterday?
No, this is your lordship.
No order was passed.
No order.
This is adjourned to today.
No. That was your lordship passed the issue notice in that case, my lord. And they also notice to the
opposite party number 5 the Bundelkhand involvement.
Yes, yes. So same order we
Same order may be passed.
Yes.
Your lordship in the interim application, my lord. Passed order, any appointment subject to result of this.
Say case number.
See case number my lord 10014.
काली जोड़ा थिला तो
आगे
आइटम टा कितने मन पड़ो
item thila item 11.
काली जोड़ा आइटम है ना same order will pass
Same.
yes
Item number 17. Urgent set.
present copy 17
May I please your lordship? Your lordship, similar matter as item number 11. Your lordship, regularization of service of Gana Shikshaka in the light of judgment of
copy of that order
yeah, after recess, your lordship.
Here also, my lord, more than one petition.
say order टा हो you do more than one है हाँ
Your lordship, I will provide the corrected copy after recess.
इतरे यदि more than नहीं चाहिए इतने कैसे नहीं इतने कौन इतने नहीं इतने कि जो रिलाय ग्रुप इतने already से representation file करते हैं
इतने भी सबूतरे representation file है
हाँ
किंतु दूसरे more than one petitioner सस्मिति
अच्छा सीट कल कर देवे
entertaining your that type of case में your lordship had passed that
कल कर दूँ तो ये इतना कर दूँ
and
ये कौन single representation
Your lordship, yes, yes. No, sir. Election line, single.
Four petition.
no, let single representation submitted by yes.
Submitted to the under applied annexer which 9. But there are 4 number of petitioners.
no you have to submit for different
Different.
That is what your lordship had observed in the previous case. Yes.
This case, trace representation to be filed.
yes
He was the contracting counsel.
ये कर दियो तो से order टा अच्छी दे दूँ हैं
Say order done the other order.
पूरा number और कौन order दूँ तो मैं कर दूँ हैं
So number date.
same order पर तो जो individual representation से इतना liberty is granted to them to file individual representations
Your lordship, item number 11 is also same as.
Yes.
item number 11
11 is also similar.
अच्छा item number 11 भी same कर दो
17 and 11.
yes
Item number 18.
18 also same.
Same, my lord. There also, my lord, more than one petitioner sir.
चलिए से corrected ही छी
Corrected
Nice,
last past जोड़ा representation सेटा से number टा दे दे
এটা হচ্ছে individual এটা হচ্ছে individual
तो individual आप कर दियो तो yes
Item number 19.
Your petitioner has failed to get area side dues prior to 194 that is equivalent to 94. Similarly situated employees of the private high schools were allowed to by government to draw such area dues. Person to order
આપણે એ માઈક કો असना देखे बी माइक मझरे क्या थे छिन माइक पर फोकस तो
person to a letter of the government under annex 3 petitioner schools under National Circle declared by the government as eligible high school to get granted since 1991. Government pleased to concur the payment of granted with effect of 194 on 5/95 they have compelled to petitioner to furnish an undertaking not to claim area dues prior to 194. Against that order, petitioner filed the petition filed a writ petition on 2000. Petition filed petition 2000.
You are claiming your salary prior to 1694.
1694.
You on what ground?
On the ground that the similar persons are situated under, I have given the statement a written note of submission that similar situated schools have given the area dues for that period prior to extra.
Yes.
Sole prayer.
Yes, Mr. Patnaik, what is your stand?
Previously, we had filed one counter, my lord.
You have filed also an additional counter, I find.
Yes.
Yes.
As your lordship wanted to know some more facts, my lord, in this regard.
Yes.
So we filed one additional counter. And in that additional counter, my lord, we have stated that this is not only the case, there are several cases which were filed wherein this honorable court observed something, my lord, and thereafter taking into consideration all these points, the government has already decided not to extend this particular benefit. A general order has been issued, and
That order has not been challenged.
no. And my lord, though I had discussed all these points, my lord, but I didn't have enclosed any copy of the same, my lord.
Where is that order of the government?
So ମୁଁ ଏଇଟା ଗୋଟେ
No, it's not.
having a copy.
ये कौन है?
They did, sir. ଏଇଟା last time.
नहीं नहीं ଆପଣ you have not given it in your additional counter.
No, say the additional counter, I had taken that particular stand, but since I had not enclosed that copy of the decision, my lord,
Yes,
that is
yes.
why I will
The government decision.
on the last occasion, my lord, I had also produced it.
You have produced it.
Yes. A letter dated 7/5/2024, my lord.
It should seem to be here. नहीं है.
Sir, ମୁଁ ଆଉ ଗୋଟେ extra ଦେଇଦେଇଛି.
ଥିବ କୋଉଠି ରହିଯାଇଥିବ ଫାଇଲରେ
ଦେଇଛି ତ, sir.
କାହିଁକି ହେଇନି? ଆପଣ ଦେଇଥାଇ ପାରନ୍ତି ସେ
ମୋଠି extra, I have also extra copies. My lord, the first document which is enclosed to this, my lord, that is at 7/7/2012, that is the decision of the government on this identical issue, my lord. And that is a guideline for the cases for the area salary prior to 1/6/1994.
No, but if after passing of this order,
Yes.
according to him, some other persons have been, I don't know, some other persons have also been granted the
There are
benefit.
cases before this honorable court, and those cases were the decisions of the honorable court were complied. And my lord, he has relied upon few cases also, my lord. Those citations. But in this case, my lord, there is a factual difference. The factual difference is that, my lord, in the year 2000, my lord, for the self-same relief, my lord, he had approved before this honorable court. In the year 2006, it was dismissed for default. He didn't take any step. That order is still in force. And in the meantime, my lord, he approached before this honorable court 3 times in different other cases. But he didn't restore that particular case. Now he's taking a plea that since in other cases that has been extended, so I may be extended because it is purely it is relating to arrears salary, my lord. That is why it is not actually a continuous cause of action. It is an arrears salary, my lord, for that particular period. So, my lord, apart from the other facts, taking into consideration the decision of Honorable Appeals Court also, my lord, we have stated that it is a stale claim and it cannot be entertained beyond a period of 3 years, my lord. And
That,
this
that what is that?
Tarsensi. That stand we have taken, and that reference also.
Valid by way of a memo. And that's the documents by way of a memo. That's how we'll conclude. We'll keep it reserved for judgment.
Madam, I may say something. That I have given the particular instances. Kindly see, my lord.
What is your reply? What is your response to his submission that your previous rate application was dismissed for default and you have now?
Default, I have asked to quash the undertakings. No, to quash that undertaking due to fault of the non-operation of the council with petition that has been dismissed. But that is the cause of action for that. This is a new cause of action. When they have denied us. They have given all others that has been decided by the Supreme Court or High Court. They have given all these things that I have noted in your lordship may go through. You gone through that the judgment that matter will be clear. They have given that bar पर हमने काउ देनी किंतु बार रे ये माने को देचन ता जोटा को इंस्टेंस देची गोटे इंस्टेंस आपन देची जोटा कि इंस्पेक्टर स्कूल्स देची कटक देचंदी 2 नंबरटा तक से सप्रेस करचंदी सेटा से निजे देचंती कंटेम्प्ट रिपोर्ट देचन पॉइंट 2 रे देची 11 नंबर पॉइंट 2 रे देची कि सेटा से सप्रेस करचंती ताकू आनाती पिक्चर को आनाती आपन सेटा से लिखिचंती जो एथे लिखिचंती देखंतु The Honorable High Court in her written statement submission in para 11, as for the Cuttack district concern, the petitioner has referred the case para 211 by order letter 18/11 passed by WPC number so and so in 2003 filed by Vikram Kishore and other versus state of Orissa by letter number 7/11 of the Inspector Schools Cuttack for the director of the secondary education Orissa. That verification of the official record, the same letter with order of this honorable court could not be traced out. Say they I have given the document, they have denied. The first thing they have suppressing the facts. My lord, they have not given all these records cited judgments I have given that has been decided by the Supreme Court. Then they have given the Supreme Court and so also the Honorable High Court. Basing on that, they have given. Not falsely, they have not given. Then after your lordship may go through the.
I have seen it. You have argued it earlier also.
Yes,
So let us close it.
Yes, ma'am. My lord, this particular document, my lord, I will submit to with the memo.
Through a memo. Have you served copy on the other side?
Yes, I have already served the copy.
All right. Hearing concluded, judgment reserved. Parties may file the note of. तो अपन तो और note file करिए नहीं? State may file if you so wants. Parties may file the note of submissions if any within a week. Yes.
Item number 20.
Losses have already heard at length, my lord. I have filed an additional affidavit. No, last occasion, my lord.
My lord, I have received a copy of the additional affidavit, my lord, in this case.
Yes.
My lord, complying to your lordship's direction, though I had submitted certain documents with respect to Basundari Gunya, I think.
Yes.
With respect to that particular person's appointment, again, that very Anganwadi center, my lord. It has been mentioned in the additional affidavit submitted by the petitioner that, my lord, without filing any document, without filing those documents in support of affidavit, I have submitted those documents in piece of paper, my lord. So, with the view to reply this particular affidavit and to bring those documents, my lord, into record through an affidavit, only 10 days time may be given so that I can submit it.
Your lordship, but sorry, but after this Honorable Court directed, yes, I have not comment. I have not. Once that they should bring it on affidavit through. Your lordship's movement to your lordship's order dated.
Where is it? Where has he stated that? In which paragraph?
My lord,
that is in my additional affidavit.
That is an additional.
Where is it? Where is it?
Paragraph number 4, my lord.
Since it has been subsequently filed later on, while filing, not filing.
Fair enough. Yeah, it is open to you to make this argument. Yes, it is valid argument. But he can also validly respond to it.
I don't dispute that, my lord, because
So you want to file those documents by way of an affidavit.
and so also, my lord, there are certain points which have been added in this additional affidavit, which I will also clarify the same.
But this cannot go on.
No, my lord.
This cannot go on.
No new additional facts have been there, my lord, but there are some.
The case of the year 2013.
My lord.
Yes, ma'am. My lord, as on date, my lord, the case is already ready for hearing, my lord. Ignoring the same, my lord, this can also be disposed.
My lord, your losses only.
You file an affidavit. You file an affidavit. Better. Let it be on record. Learned AGA, Sri S.N. Patnaik, learned AGA seeks permission, seeks an adjournment on the ground. No, here cutting. Sri S.N. Patnaik, learned AGA seeks some time to file a reply affidavit to the additional affidavit filed by the petitioner on the last by the petitioner. Stop. Release this matter on
4th of July.
4th July.
Yes.
Parties are requested to come ready for final disposal of the matter. No further time shall be granted. Yes.
Item 21.
Maybe. Here also, my last time I have filed affidavit, additional affidavit to the effect that the present petitioner has also the present petitioner husband has also a thatched house in the particular service area, and I also saw the copy to my friend for instruction. So the whole case is based on the fact that whether the present petitioner, because as per the advertisement,
it is service area or not. It is a case of mini Anganwadi center apartment. Now, even the affidavit also says, my lord.
Education will be relaxed according to Mr. Patnaik. 7 except this election, the other elections were yes.
My lord, the earlier advertisement has been cancelled as per our answer A by 1 in our counter affidavit, my lord, saying that since none of the candidates who had applied for the said post, they're belonging to this Anganwadi, mini Anganwadi service area. It is in terms of that 2007 guideline, September 7 guideline for mini Anganwadi center, my lord. The person should be of the Anganwadi service area, my lord. So that is why that has been cancelled and new advertisement and issue. So that new advertisement issued in the year 2016 challenging which this petitioner has approached.
You challenge the advertisement?
Yes. So, my lord, on the last occasion, after going to the entire records, the petitioner has now stated that
that she belongs to.
No, he stated, my lord, after my marriage, which was held in the year 2009, initially I stayed with my husband and in laws in a thatched house, which was subsequently converted to an asbestos house at Gandhipada under the service area of the Anganwadi center. And subsequently, after staying there for about 6 to 7 years, as my husband has constructed a new house by the side of Gandhipada, I, along with my in-law family members, shifted there and is residing there for last 7 to 8 years. This is a new additional fact which has been brought to your lordship's notice, and a copy of the same affidavit has also been supplied to me. And over telephone, my lord, today in the morning, my lord, I got the instruction, my lord, there was a field inquiry where it was found not to be true.
Let it come to affidavit if that is so.
And
one thing, the first advertisement annexure 1, last advertisement annexure 4. All where it has been said like this, my lord. It's all right. The first advertisement have somehow forgotten or because of some inadvertent reason, my lord, they have failed to mention that the petition doesn't belong to that particular area. And the second advertisement also the same thing. आवेदनकारी केवल महिला श्रेणी और संपुक्त अंचल बासिंदा होइतिबा सहित संपुक्त ग्रामरे बसवास करथुवे. So there is no dispute to it, my lord. In the first advertisement, let us highlight that because of some reason they have failed to comply in a specific manner, they have not said so. Second advertisement, the same thing, my lord.
Let them reply to this affidavit.
Yes.
Sri Patnaik Learned AGA request for some time to respond to the amendments made in the affidavit filed by the petitioner on 1/5/2024. List this matter on
same day, my lord. On 4/7. Yes.
List this matter on 4th July.
Yes, ma'am.
Affidavit if any be filed in reply affidavit if any be filed in the museum. Item number 22. You want to withdraw this appeal? Permitted to withdraw. File a memo. I number I तो ही I allowed. Permitted to the appeal is permitted to be withdrawn. No? Yes. Item number 23. Disclosure is withdrawn.
I mean, pardon, my lord, I am through VC, my lord.
Yes.
Item 23, I will take steps for issuance of notice to the respondent to his correct address, my lord. 2 weeks may be given, my lord.
Just. Noting. Appeal notice issued to the when did it return? SR of appeal and writ of status quo issued to respondent 1, 3, 4, 5, 6, 7, 9, 10.
But second marriage concern will be
Just. You were directed to When did you file the reports?
My lord, we have filed the requisites on 28th March 2024.
All right. So now that has returned unserved.
My lord.
Maybe issue to the fresh registered post. Insufficient address return to sender. Acha. Address cannot be located. You are appealing for all the respondents?
No, only one man. The management, my lord. It is regarding the management of a school, my lord. Let it be hard, my lord.
So without respondent number 2, without notice being served on respondent number 2.
By that time, he was the president. Now that has been.
So it is up to him. If he deletes respondent number 2 at his risk, then the appeal can proceed. Otherwise, notice has to go. Without service of notice, how can the appeal be heard? That is a big problem. You will declare address cannot be located, hence return to sender. Yes, Mr. Das. Before going to this substituted service,
sure.
What can be done? Correct address to the correct address is that I find everything has been done.
See that there are.
I don't want to pass any order on substituted service at this stage. It will unnecessarily delay it.
Then how the notice will.
So that is what I'm asking. Through court process again, Korea.
By registered post, if the address is there.
Address is there. Corrected address was also again there. So what can be done? Through both ways, both ways court process service is you.
Or newspaper publication.
Yeah, that is what I'm saying. Substituted service.
Yes.
All right. Newspaper publication
Local.
Local, obviously. It appears that despite several efforts, notice has not been served upon respondent number 2. You can also take a decision whether to continue with respondent number 2 or whether if you want to delete him as he's submitting that he is no longer relevant because he is no longer the president. So he may not be necessary.
Well, only short date may be given. I will take instruction. In the next week.
I have requested as paid for by land counsel for the petitioner. Let's this matter next week. So in the meantime, you obtain instruction. If you can delete him in every matter, we can hear the appeal.
My lord.
Unnecessary notice message you that police substituted service newspaper say they draft approve over and dunya. Yes.
Item number 24.
Let's say I will take substitution of respondent number 7 and 8. Some time may be granted. Earlier granted time on 18/3, your lordship is pleased to granted time. One more chance, your lordship.
Last chance is granted to the appellant to take steps for substitution of deceased respondent numbers
7 and 9, your lordship.
7 and 9. Let's this matter next week. It is made clear that no further time shall be granted.
Item 55.
I am for the respondent number 1, my lord.
Petitioner?
My lord.
I mean, who's for the appellant?
My lord, I number 470 of 23.
Just a moment, You are for the appellant?
Yes, my lord.
Yes, IA number, what are you submitting?
470 of 23.
470 of 23, yes.
My lord, it is in file for a direction to the court below that, my lord, what happened? So prior to passing of interim order, substitution was made in the final degree proceeding. And after that, I filed an application that since substitution has been allowed, notice is to be issued to the legal heirs. That has been turned down. Only more the purpose of filing of I is that the lordship and direct the court below that only issuance of notice for the limited purpose. Only for issuance of notice. Because after substitution, notice is to go. That only I am preparing, my lord.
My lord,
I am not saying the further proceeding will continue. Only for the purpose that since substitution has been made, only notice is go to the proposed legal heirs, my lord. That was the only prayer, my lord, in the IA.
Yes, what do you say?
My lord, the present appeal is also to be regularized because, my lord, many of the appellants and respondents have died, my lord. And we have filed respective applications.
You have filed all those applications are on record?
Yes, my lord.
We can take them?
Yes, my lord.
Those cases? And this first let us dispose of this application,
my lord.
My lord.
There you have got nothing to say.
No, my lord. My lord, proceeding may be stayed and no notice may be go, my lord.
IA 470 of 2023. that order sheet, my lord, that I have obtained. This is an application filed by the respondent number one. Respondent number one. With prayer to direct the court below to proceed with the final decree proceeding. Only for the purpose of, only for the limited purpose of issuing notice to the legal heirs of the deceased. K. Deceased respondent number one. Deceased respondent number one. Learned counsel for the appellant has no serious objection to the prayer being allowed. Under such circumstances, the IA is disposed of directing the Civil Judge Senior Division Soro to proceed with the TS number 126 of 2009 bracket FD only for the purpose of issuing notice to the legal heirs of deceased respondent number one. Yes. Now we'll take up all these. Let us regularize it. Gotti kuhନ୍ତୁ ସବୁଥରେ ତିନି ତିନିଟା କେତେ ଜଣ ପାର୍ଟି ମରିଛନ୍ତି କିଏ ମରିଛନ୍ତି କୁହନ୍ତୁ
R7 R15
ନା appellant ଆଗ କହୁଥିଲେ
appellant my lord appellant number 3 my lord
appellant number 3 ତାଙ୍କର petition କଣ କୋଉଟା ତାଙ୍କ petition
flag D my lord
କୋଉଟା ମିସକେସ୍ ବା କଣ ନମ୍ବର କୁହନ୍ତୁ
my lord IA number 495 of 22
IA 495 of 2022 this is for substitution
yes my lord
and what is for ତାଙ୍କର ତିନିଟା petition ଥିବ limitations or
496 497 and 498
IA 496 ଟା କଣ
496 496
setting aside abatement ତ ଗୋଟେ ଥିବ ନା ଆଜ୍ଞା
my lord 490 setting aside abatement is 497
yes
and 498 for delay my lord
IA 498 for delay 497 ହେଲା setting aside है
my lord
so 495 497 and 498
sorry my lord 496 495 496 and 497
496 ଟା କଣ setting aside abatement
yes my lord
497 ଟା delay ହେଲା 2
that is named Gopinath Acharya
whatever respondent 2 कर दो
and petition number 2 in the court below that is
learned ଏଇଟା ଖାଲି କରନ୍ତୁ ବାକି ଏଇଟା allow କରିଦେଲା କରନ୍ତୁ as requested by learned counsel for the appellant let this matter
substitution copy ଯାକ ସବୁ ଦେବେ ମତେ petition copy ଆଇ ଗୁଡାକ
in the meantime we why will you get copies of the substitution why will you get I don't understand you are applying for only for respondent number one so let it be allowed allow କରିବାର କିଛି ନାହିଁ but ସେ ଯୋଉ order ତ pass କରିବାକୁ ପଡିବ କୋଉଟା କାହାର କେମିତି ଜାଣିବା ଆପଣ
my lord I will give a tabular form my lord may keep it to tomorrow my lord
all right tomorrow
my lord that I will dispose of
that I will dispose of it will ରଖିଲା କଣ
ଆଜ୍ଞା
let's just matter tomorrow
my lord our extension of so interim order ପାଇଁ ଥିଲା
କାଲି ହେଲେ ସବୁ ନବ କାଲି ନେଇଯିବ
that become a because that after full court judgment and SRS proceeding
what that when did he die ଆଉ ସେମିତି କହିଲେ କେମିତି ହବ ଆଜ୍ଞା ଆପଣ ପ୍ରିପେୟାର କରୁନାହାନ୍ତି 2 weeks time is allowed to the 2 weeks time is allowed for taking steps for substitution soon
when the state sought for some time to comply with the earlier order dated 29/9/2015 wherein they were directed to produce the
which order do you want
9/10/2023
9/10/2022 my lord
Para 2, Mr. G. Biswal and counsel for the petitioner by drawing attention to the court to the order passed on 29/9/2015 seeks direction to the opposite learned AGA prays for a short adjournment to comply the aforesaid order or file an affidavit by serving an advance copy by the next date.
Yes,
Counter affidavit has been filed, but the records I have not got.
Is it necessary?
Or file an affidavit.
Or file an affidavit. So you have already filed an affidavit?
Yes, counter affidavit has been filed.
But as far as the record relating to the proceeding before the director is concerned, that has not been enclosed in the affidavit, counter affidavit.
Let us hear it for a moment. This has come to this court for the first time. I don't know the matter. Let us hear. If it is not necessary, it will not be necessary. If it is necessary, we will call for. What are you challenging?
The petitioner, I am challenging order of removal, which was upheld, confirmed in the appeal. Subsequently, I approached this honorable court, wherein this honorable court directed me to approach the OP number 2 to reconsider my case. OP number 2 is the director to reconsider my case. But the director, without assigning any reason.
Where is that order?
That is at page 28. Without assigning any reason, has referred to
not Nandan Churia. Yes, Mr. Das.
Sir.
Non-specific. Non-speaking. It's not a speaking order. This second paragraph that you are says that he makes up his mind. Then finally says, since the High Court has directed me, I will consider it. And I find no infirmity, I am not inclined.
Parties were heard the parties concerned at length, as well as to consider the material available on record. In my considered opinion, there is no legal infirmity in whatsoever in the order passed by my predecessor. Therefore, representation has no merit.
Unfortunately, this is a case of the year 2011.
Yes.
Ordinarily, it should go back. What to do?
Now, the governing body's action was impugned.
Maybe it's an order of termination.
Yes.
13 years back.
Yes.
What can be done now? This order cannot stand.
Of course, it is not a reason order.
Not a speaking or reason order. This court, when this court remands the matter,
yes.
Obviously it means that you have to give reasons. And if you don't give reasons, then their entire action goes. And 2011, at this distance of time, again relegating the person to the director could be a bit harsh. What is it?
In fact, the governing body's action, let the governing body justify as to how he was.
No, that will be entering into the factual aspect, isn't it? There is certiorari jurisdiction. Why will the court enter into such details?
Let him give reasons and to Annexure 5.
He has simply reiterated that order which was set aside by this court.
Yes. No infirmity.
Yes, no?
No infirmity, he says.
No infirmity. What is the meaning of it? He has to justify his order. The earlier order is at Annexure 4.
Let him do it.
Yes, ma'am.
Even though the same incumbent will not be there.
No, any person will be there. What do you say? We'll send it back.
My lord, may remand it back.
And this court cannot hear it. Factually, I may decide to say so cause by we cannot listen.
They direct the parties to appear before the director, both the parties, the governing body, and
director. He has to assign reasons. Pass a reason order. That's all. Whatever he may pass, so that you get a fresh cause of action. Either if it is goes against you, you may challenge that order.
The governing body is not represented at present before your lordship now.
Notice was not issued. Notice was sufficient.
They have appeared.
They have appeared. They are not there. And there is an intervener also.
As your lordship.
There is an intervener also. Governing body is opposite party number 3. Let us see whether notice has been issued or not. पेंडिंग रखी लाभ कुछ नहीं अल्टीमेटली से ऑर्डर ही हो Postal AD as against opposite party number 3 back after valid service. Opposite party number 3 is the managing governing body. Rather. অনেক থর লেখা হয়েছে valid after valid service. Intervention by one J. Mendali through Mr. Shobhan Panigrahi.
Mr. Shobhan Panigrahi perhaps appears.
No, he is appearing for the intervener. Somebody was an intervener. Probably the termination vacancy right say. Your name is Mr. Shekhar.
My lord.
What Shekhar?
Shakti Shekhar.
Shakti Shekhar খালি ইসে ছিল আগে নাই পছন্দ নেই
আচ্ছা কিছু
যা বুঝবে আর শ্রী এস শেখর learned counsel for the petitioner and Sri Ardas learned AGA. The petitioner has approached this court with the following prayers. The facts relevant only for deciding the present writ application are that the petitioner would empty bomb. Achha. Why should we say the entire facts? Achha. The petitioner was appointed as a lecturer in botany in Hasimal Ancholiko Vidyalaya, Hasimal in the district of Baleswar.
The district of Sambalpur.
In the district of Sambalpur on 22/8/1993. When was that advertisement issued? Annex 2.
That is not
As per
specified.
No, that it is not the subject matter now.
No. How did he come to the? Why did he file appeal? That has to be stated, na?
Yes, because of the action taken against him.
That I have to briefly indicate.
Yes.
I have to briefly indicate. By letter dated, it can chari no.
That is 9/9.
2004 of the secretary of the governing body of the college. The petitioner came to know that he had been terminated from his post. Accordingly, he challenged the order of challenged such action of the governing body by filing an appeal before the Director, Higher Education.
In the year 2011.
In the year 2011. 2011, no, yeah. That was in 2004. 2005. 2005.
My apologies.
No, 2004. Well, nije fact to the clear note. By order dated.
4 years. My apologies.
By order dated 16/5/2005, the director after going through the records and upon hearing the parties did not find any reason to interfere with the order of termination. Accordingly, the appeal was dismissed. So, the petitioner approached this court in
WPC 678 of 2009.
WPC number 678
of 2009.
Of 2009, challenging the order of the director as above. This court, by order, where is that order?
29, that has not been annexed, Your Lordship, but I have quoted it, stated that in para 18. White order dated 29/1/2009.
By order dated 29/1/2009, this court set aside the.
My lord, the court did not set aside the order. It simply directed the opposite party to take action on the recommendation.
Remanded the matter to the director for reconsideration. Reconsideration, particularly on the grounds raised by the petitioner regarding violation of the principle of natural justice. Pursuant to such order, the Director, Higher Education, heard the appeal afresh, but by order dated 1/3/2011, not at 25/2/2011 each, sign each. By order dated 25/2/2011, again rejected the same. Copy of such order has been enclosed as Annexure 5. In the said order, the Director inter alia held as follows. In my considered opinion, stop. Be it noted that the earlier order passed by the Director on 16/5/2005 was a reasoned order. The order impugned in the present writ application is, however, entirely non-speaking and sans any reason whatsoever. The Director has not taken the trouble of stating as to how the as to the reason for holding that the previous order was did not contain any infirmities. It is stated at the cost of repetition that this court, while directing the Director to reconsider the matter, had specifically directed that the points raised by the petitioner regarding violation of the principle of natural justice should be considered. Reading of the impugned order, however, reveals that no such effort has been made by the Director, nor any finding thereon has been rendered. So, this obviously makes the impugned order vulnerable to challenge. This court is therefore of the view that the impugned order cannot be sustained in the eye of law. The writ application is therefore allowed. The impugned order under Annexure 5 is hereby set aside. Matter is remanded to the Director of Higher Education to consider the appeal afresh in accordance with law and to dispose of the same by passing a reasoned order touching all the grounds raised by the petitioner, particularly the ground relating to ground of violation of the principles of natural justice. Stop. Since this is a case of the year 2004, the appellate, the Director shall do well to dispose of the appeal as early as possible, and in any case, not later than 6 weeks.
Yes, 6 weeks under the situations because no regular Director has been so far.
I'll make it 8 weeks then. 2 months.
2 months.
And in any case, not later than 2 months from the date of production of certified copy of this order by the petitioner. Further, the Director shall also afford opportunity of personal hearing to the petitioner and all other necessary parties after issuing notice to them.
Item 29. My lord, in the last order, your lordship directed me to file a recusation for the opposite party number 3 for as it was returned back. Inadvertently, it could not be filed. I am filing today, my lord. That may be accepted and my date may be fixed after 2 weeks because that will take 10 days time. to be served on them.
Learned counsel for the petitioner seeks permission, undertakes to file the requisites in course of the day. If such requisites are filed, notice be issued as already directed by order dated 8/5/2024. List this matter. Huh? On 10 July, 10 July रे हबो नहीं. 10 July आप के लंबा कर दे. Last week को नहीं जाए. 25th July.
25th June.
July. Along with the WPC number 20551 of 2011.
Yes.
Item 30.
No instruction, man.
No instruction dispose of. Hello.
Item 31.
May I please, Your Lordship? My lord, the petitioner who has been selected as Anganwadi worker of Dhumavatta 4 Anganwadi Center in the district of Balangir. My lord, she has challenged the order dated 22/4/2015 passed by the Laland ADM Balangir in Anganwadi appeal number 7 of 2011 under Annexure 1, wherein her selection and appointment has been set aside by the ADM on the ground that the said appeal was filed at the instance of the present opposite party number 5 on the ground that the present petitioner doesn't belong to the Anganwadi center area. Your Lordship, may kindly see the impugned order, which itself is self-contradictory, page 13. Because as per the survey by the government itself, my lord, she is a permanent resident of that service area because there are 7 podas that constitute the Dhumavatta 4 Anganwadi center, and one of them is Ranapada, and the present petitioner is a permanent resident of that. Your Lordship, may kindly see the impugned order at the relevant portion, page 13. My lord, 7 line, as per objection filed by the petitioner. At the CDPO Belpada has issued notification by notification number 220-24/7/2009 inviting application from the suitable candidates living in service area of concerned Anganwadi center, which includes Kotkiapada, Malikpada, Ronapada, the present petitioner is met, and she is the highest secured highest mark, my lord. Malipada, Boidapada, Pathanpada and Luthrapada of the village Dhumavatta. As per the notification, appellant, respondent and others 9 candidates filed application along with the requisite documents as per the norms of notification for the post of Anganwadi worker Dhumavatta 4 Anganwadi center. As per objection filed by the petitioner, a meeting was conducted in the village Dhumavatta on 15/2011 in presence of the SSWO Patnagar, Sarpanch, ward member and villagers to inquire into the matter that the applicants applied for the post of Anganwadi worker belongs to Dhumavatta for Anganwadi center service area or not. As per the resolution, the respondent, Srimati Gandharvi Patharimali, who is the petitioner before Your Lordship, my lord, is found to be the resident of Ranapada, which is coming under Dhumavatta 4 Anganwadi center area. On perusal of the survey register of Dhumavatta 4 Anganwadi center conducted during the year 2011 by Srimati Gandharvi Patharimali, it is found that the name of the respondent is enlisted in serial number 171 of the survey register, but the survey was made during the year 2011 after selection of Anganwadi worker of Dhumavatta 4 Anganwadi center, which cannot be taken into consideration. Tahsildar Belpada also submitted an inquiry report regarding the residential status with Gandharvi Patharimali. As per the inquiry report, the respondent Gandharvi Patharimali is residing with her family in Mandirapada village Dhumavatta, which is coming under the Anganwadi center 1 of the village Dhumavatta. In view of the above, I am the consider opinion that Srimati Gandharvi Patharimali is a permanent resident of Mandirapada of Dhumavatta village, which is coming under ward number 8, and Mandirapada is coming under Anganwadi 1 center area. Taking into consideration the facts and circumstances of the case, I am of the consider opinion that the appeal is allowed and engagement of the respondent Gandharvi Patharimali Anganwadi worker is set aside. Well, in the meantime, the husband of the petitioner has also died and she has become a widow, and by virtue of the interim order passed by this honorable court, she is continuing since 2011, my lord, till date. And the opposite party number 5 was also noticed and she has entered afference. Perhaps yes, she is engaged elsewhere as per my instruction, but I cannot authentically say, my lord.
Yes, Mr. Das.
Yes, Lord, I cannot say beyond what the impugned order speaks. Now, the specific finding has been that she belongs to the area as it has been mentioned, which is not coming under the Anganwadi center, for which the selection is now being made.
Tahsildar Belpada also submitted an inquiry report regarding residential status of Srimati Gandharbi Pathrimali. As per the inquiry report, the respondent is residing with her family in Mandirpada. So in 2011 survey, you were residing in that Ranapada or whatever, Ranapada.
I am appointed in 2011 itself, my lord. Appointment letter, your lordship, may kindly see the selection order, annexure 3, my lord.
No, but if being already appointed, you also, what is the rule? What is the guideline? Guideline says that a person who is the Anganwadi worker has to stay within the same area.
Same area.
Must be a resident of that area.
Residence of deputy, if not.
What we find is that during her engagement, which was in the year 2011, she was a resident of the service area of that.
Ranapada, 1 number 8.
Now, subsequently, there was some inquiry and it was found that she has moved to some other place.
Yes.
That will not disqualify her.
But if
So her appointment will be challenged. If
at the time
she may be disqualified, she may proceeding may be initiated against her that you are, since you are no longer as a resident of the service area,
Yes.
so you cannot be you have to show cause why you will not be terminated.
continue.
You cannot continue, you have to disengage. But her appointment, initial appointment cannot be questioned. What do you say?
Lordship may remand it for reconsideration.
Why?
Let's see, it's continuing.
Why?
No, not at the appellate stage by the committee itself.
No, why? Her appointment was, it is not said that her appointment was wrong.
Initially.
Initial appointment was right.
But if in the meantime this development has taken place, that
So it shall be open to them to proceed against her.
Yes.
But her appointment, they can proceed in accordance with law. Is there any provision for that effect, to that effect? In the guidelines?
That I have not checked out.
No. But they can always proceed. Because it will amount to violation of the condition that you have to be, you belong to that service area. Supposing subsequent to your appointment, you move to another service area. So that violates the condition. For that, they can proceed against you. But
other documents, with great respect, my lord, the residential houses survey, everything I have annexed. She is a resident of that village itself, my lord. All the documents that has been verified by the committee, selection committee.
No, it's not a question of being a resident of the village. It's a question. It is rather a question of being
within the area.
A resident of the service area.
Those surveys are below relating to Ranapada, and I am a resident of that Ranapada 1 number 8, my lord. That is my humble submission, my lord. And your lordship may kindly see the Dhumawata 4 consists of 7 pada and Ranapada is one of them.
No, that is true. That is true. That I have seen. That you have read out.
That is also in advertisement page 15 also, my lord.
No.
Serial number 15, Kotkia pada, Malik pada, Ranapada. And my residential certificate has not been challenged by, my lord, any person.
But each Anganwadi center has its own area.
Service area. It is not the case of anyone that at the time of appointment, she was not a member of that Ranapada. She was a member of that Ranapada. That is why she was appointed. Subsequently, the survey, which probably took place sometime around
report of the Tahsildar.
15, my lord, after 15.
2015. So that gives rise to a different cause of action. But for that, her initial engagement cannot be challenged.
Which was not violative of the condition.
What do you say?
Your lordship may.
I'll set aside.
Liberty with the selection committee.
It shall be open to them.
She has become a widow in the meantime, my lord.
Yeah, that's all right.
My lord.
That's all right. If there is no other person present within that service area, then she can be considered.
That is the guideline also.
That is the guideline. Being a widow is an additional
guideline was there, my lord. She must be a resident of the village / service area.
Mr. Nanda, the question of the point that you are raising that she has become a widow in the meantime is not relevant. Because being a widow adds some mark at the time of selection. Now you are already selected. You are already engaged.
Hey, at that time, she was not a widow.
She was not a widow.
Now, with the passage of
fresh appointment, applicant have widow weightage mil pare. But not that. So here let us see the impure order again. Here he says very clearly, admittedly, notification
the Sarpanch has written, ward member has written, everybody has given certificate that she is a resident of Ranapada. That has also been reflected in the impinged order as page 13, that as per the survey, the respondent belongs to Ronapada.
Who is appearing for the private opposite party?
She is also engaged elsewhere as per my instruction, but authentically I cannot say, my lord.
MR Samantha.
And she secured highest mark also, my lord. Page 12 it has been mentioned.
She may be continuing also now because of the status quo.
Status quo. She is continuing, sir.
Well, set it aside. Set aside. The petitioner has approached this court
with the liberty with this selection.
I'll just make an observation. I'll not grant any liberty. I'll just make an observation. Why should I grant liberty? See, what who stopped you? Somebody, a private appeal was filed at the instance of a private party, never at the instance of the authorities. It is for the authorities to always find out. Why will the court grant them that liberty? Let's file this with the following prayer. Parat. The facts of the case are that pursuant to an advertisement. Pursuant to an advertisement issued on 24/7/2009 by the CDPO Belpada in the district of Balangir for engagement of Anganwadi workers in different Anganwadi centers, the petitioner submitted her application for the Anganwadi center at Dhumabhota 4 Anganwadi center. Anganwadi center at Dhumabhota 4. The present opposite party number 5 was also one of the applicants. In the selection committee, the selection committee found the petitioner the most suitable among all candidates, and accordingly, her name was recommended. Accordingly, she was selected for engagement. Pursuant to such selection, the petitioner was engaged as Anganwadi worker and joined as such on.
Joined since 31/3/2011.
31/3/2011. Stop. The present opposite party number 5 filed an appeal, being AWW appeal number 7/2011 before the ADM Balangir, challenging the selection and engagement of the petitioner on the ground that she is not a resident of the service area of the Anganwadi center. Stop. The petitioner contested the appeal by filing necessary records and documents. The ADM, as per order dated 22/4/2015, basing on the report of the Tahsildar Belpada, held that the petitioner, being a resident of Mandirpada of village Dhumabhata, is not a resident within the service area of Dhumabhata 4 Anganwadi Center. As such, the appeal was allowed and the engagement of the petitioner was set aside. The petitioner has approached this court, impugning the order of the ADM, a copy of which is enclosed as Annexure 1. Heard Sri Lochan Nanda, learned counsel for the petitioner, and Sri R. Das, learned AGA for the state. There is no appearance from the side of the opposite party, no appearance on behalf of opposite party number 5, despite repeated calls. Sri Nanda would argue that Dhumabhata 4 Anganwadi Center comprises of as many as 7 podas, including Rana Poda, of which the petitioner is a permanent resident. Stop. In course of the selection process, also her name was found placed in the voter list of said ward and also the survey register. Stop. Moreover, she secured the highest marks. Thus, taking into consideration all the above facts, the petitioner was rightly selected. Rightly selected. So, the ADM has himself accepted that as per the survey register, the petitioner is a resident of Ranapada, which comes within the service area of the concerned Anganwadi Center. However, basing on a purported inquiry conducted by the Tahsildar, it was erroneously held that she is a resident of Mandirpada, coming under Dhumabhata Anganwadi Center, Dhumabhata 1 Anganwadi Center. Sri R. Das would argue that as per the guidelines, an applicant has to be a permanent resident within the service area of the Anganwadi Center in question. In the instant case, the Tahsildar Belpada conducted an inquiry which revealed that the petitioner belongs to a different service area, is a resident of a different service area. And therefore, the ADM rightly set aside her selection as Anganwadi worker, para. This reading of the impugned order shows that Dhumabata 4 Anganwadi Center includes 7 podas, namely Kotkia Poda, Malik Poda, Rana Poda, Mali Poda, Boidu Poda, Pathan Poda, and Luhura Poda. Nine candidates had applied for the post of Anganwadi worker. An objection being filed by the present opposite party number 5 before the selection committee, a meeting was conducted on 15/3/2011 in presence of SSWO, Patnagar, Sarpanch, ward member, and villagers to inquire into the matter. The survey register of Dhumabata or Anganwadi Center, basing on the survey conducted in the year 2011, shows that the name of the petitioner is at serial number 171. This, parenthesis, shows that the petitioner is a resident of the service area of Dhumabata 4 Anganwadi Center. The ADM, however, has held that such survey was conducted during the year 2011 after selection of the Anganwadi worker. Nothing further has been stated as regards the dates of appointment, as regards the date of conduct of such survey. Be that as it may, further, the Tahsildar Belpada appears to have submitted an inquiry report. Copy of such inquiry report has not been filed by either of the parties. In the said inquiry report, it is stated that the petitioner is a resident of Mandirpada of village Dhumabata, which comes under another Anganwadi Center. That is that is Anganwadi Center 1. There is no definite material to show that the petitioner was not a member of, not a resident of Ranapada in the year 2011. The impugned order does not specify, does not also specifically mention that she was not a member of, she was not a resident of Ranapada at the time of her selection. It is only during hearing of the appeal, it is only during pendency of the appeal that the Tahsildar Belpada conducted an inquiry which purportedly revealed that she is a resident of another resident within the service area of another Anganwadi center. Stop. Unless there is definite and clear-cut evidence to show that the petitioner was not a resident within the service area of the Anganwadi center in question, her engagement as such, her engagement as Anganwadi worker cannot ordinarily be questioned. It is also accepting the inquiry report of the Tahsildar for a moment. It only raises the possibility that the petitioner may have shifted her residence to Mandirpura after her selection. Stop. If such is the case, it would give rise to a different cause of action to proceed against her. But under no circumstances, her initial engagement, her initial selection and engagement can be questioned. This is being said for all the more reason as it is not the case of the opposite party number 5 appellant that the petitioner is a resident of Mandirpura and not Ranapura, excepting for stating in general terms that she was not a resident of the service area of Anganwadi Center 4. This court further observes that the petitioner has been working as discussion made here and before. This court finds that the finding of the idiom regarding the residential status of the petitioner is not based on definite evidence or material so as to justify setting aside her engagement, her selection and engagement. As such, the impugned order is rendered unsustainable in the eye of law. In the result, the writ application is allowed. The impugned order under Annexure 1, impugned order dated 22/4/2015, passed by the ADM in W Appeal number 7 of 2011, is hereby quashed. Quashed and set aside. Yes.
Grateful. Ignore 32.
Password.
Ignore 33.
May I please your lordship? This is an Anganwadi case. The present petitioner was selected as an Anganwadi worker. The opposite partner of 5 challenged the selection procedure of the present petitioner, and the appeal was allowed on the ground that the caste certificate produced by the present petitioner is fake. On that ground, the entire selection procedure was quashed. In this case, no notice was issued to appeal number 5, as because the Honorable Court bench first said that once the certificate is found to be genuine, thereafter will issue notice. So, lordship, kindly see the impugned order under Annexure 1.
Just a moment. No, on the last occasion, you were directed to take instructions whether the father of the petitioner belongs to scheduled tribe or not. Notice has not been issued.
No.
So whether the court wanted to be prima facie satisfied, whether there is any merit in the, because if the caste certificate is found to be fake, so obviously the order will be justified.
Sure.
So you have to find out whether the petitioner's father belongs to the scheduled tribe or not.
That instruction I have not got.
I'll grant you 2 weeks time.
No, there is no interim order, so that the fresh selection can be started at any
You
time.
file an IA? Have you filed an IA?
File IA is there. Actors proceeding already disengagement.
Disengage is allowed.
No fresh selection shall be started.
That's true. No fresh selection. Any selection made shall be a result of this writ application. That order I can pass, but notice has not been issued. So this order has to be complied with. The order of the coordinate bench. Then only because it can be decided whether to issue notice or not.
Sure.
I'm granting you 1 week time.
Sure.
Then I will pass order that. Let this matter next week. The previous order be complied with positively. Yes.
I pray for interim.
Next week as well. Next week as well. Next week as well.
23 matter, you also knows.
Next week as well. Next week as well.
Once the assignment is changed, it cannot be listed.
Next week as well.
Yes. So outcome.
No, next week as well.
Date may fix.
Next week, next Thursday. Yes.
Obliged.
The order is correct. But when one line is left, before inquiry, he will give the notice to all the parties. That portion has not been indicated. Therefore, I filed the modification. I mentioned in the vacation, it's not allowed.
Considering the submissions, the following sentence be added at the end of paragraph 4. Further, the collector shall grant opportunity of hearing
To all the parties.
to all necessary
Prior notice.
to all necessary parties
Prior notice.
by giving them prior notice.
Preparation.
Yes.
At least.
Fixed. Place this matter on the date fixed upon.
Right. Item 35.
Petitioner is in custody, my lord.
My lord, in the previous case, a free copy may be supplied to me so that I can hand it over.
Free copy of this order will be handed over to the State Council for compliance. It is item 35.
Para 9, your lordship kindly.
Wait. What is this matter? Let me see. Is it?
302/34 of the IPC. Allegation is that, my lord, FIR named accused person 10 and 20 others came and diffused in filthy language, also assaulted.
I'm sorry.
FIR named accused person 10 in number. FIR named accused person 10 in number, my lord.
You are named. You are also named.
Named. Who was named, your lordship granted bail. And other co-accused also granted bail, your lordship elaborated in para 9.
So PW1.
Again.
Where is that PW1 deposition?
Yes.
What is your name?
My name is
Vikram Narendra Singh.
Yes.
Directly
Directly ମାନେ ସିଏ କହିନି specifically.
PW1 ଆମେ ଦେଖିଥିଲେ?
ଆଜ୍ଞା ସେଟା ଲେଖିଛନ୍ତି ପରା.
PW1 name your lordship.
Yes.
PW1 ତ ଅଛି ପରା.
Copy of his deposition has been produced. Your lordship para 9, your lordship kindness.
Vikram Narendra Singh, Duli Pradhan, Surya Pradhan, Hadia Pradhan,
Gandhar Parida, Jitu Parida and others.
My father and everybody, our named person says my father holding Katti, Bhujalesa,
and PM report, your lordship, 4 laceration injury, 3 in leg, 1 is eye. That has been elaborated in order.
But she has given your name.
She is the eyewitness. 2 persons were eyewitness. That the son and daughter of the deceased, they were eyewitness. They are specific the name of the present petitioner and another 2 persons. That
ଡୁଲି ପ୍ରଧାନ ଇଏ ଥିଲା
Duli.
ନାଇଁ ନାଇଁ ତା ନାଁ ବି କହିଛି ତା ନାଁ ମୋ ନାଁ ଆଉ ସୂର୍ଯ୍ୟ ପ୍ରଧାନ ନା
Surya Prasan has not preferred any bail petition.
no and Duli lordship granted bail the petition is Bikram and 4টা lacerated injury 3ଟା leg ରେ ଗୋଟେ ଇଏ
No, because
All
she was a
that
lady. She was a lady.
your lordship consider on merit my lord TW1 your lordship indicate that I am aware of that fact my lord I am giving the copy page para 9 your lordship kindly see near about 3 years he is in custody
for what
And my lord, he is also not coming on the similar footing because the leading to discovery that Katti and Bhujali, it was seized from the present petitioner, not from the Bully brother.
and not to vital part of the body that doctor has been examined 4 laceration injury 3 to leg 1 to eye my lord that has been considered by your lordship and granted bail.
That was in case of that lady because she was just a part of that group. Here,
He also named in the affair 162.
No, I have seen, but there is no
witness specifically named.
Mr. Sahu, here there is a leading to discovery of the weapon at the instance of this petitioner.
I have read out the statement of the eyewitness, son, my lord. He has specifically uttered the name of the Duli, Bikram and Surya Pradhan. Your lordship consider Surya Pradhan, other co-accused person granted bail. I am not giving my lord. That elaborate thing has been made in para 9 my lord. And 3 years custody.
I have seen that para 9.
Yes.
Para 9 of PW1.
No, 8 order. Order.
No, that I have seen. But you come to this deposition.
Deposition my lord.
Para my father was wearing a green color ganji and black color pant. I cannot say how many people ran away from the spot where my father was lying as it was darkened. But they are Bikram Narendra Singh, Duli Pradhan, Surya Pradhan, Kali Pradhan,
I also granted bail.
Yeah, all right. But I consider Duli Pradhan mainly because she was a lady.
Also granted bail, my lord. Examine ହେଇଛି କିନ୍ତୁ FIR ଟା ଦେଖିକି your lordship consider.
The principal accused appeared to be Surya Pradhan and Bikram Narendra Singh.
Yes. That is in Ganga Parida.
No, only she had seen the petitioner and another person moving near the house on her motorcycle.
Yes, my lord. FIR ସେଇଟା 161 ରେ କହିଲା eyewitness 3 ଜଣଙ୍କ ନାଁ କହିଲା ଯୋଉମାନେ ଗଲେ 3 ଜଣ ହେଲେ ଡୁଲି ପ୍ରଧାନ ସୂର୍ଯ୍ୟ ପ୍ରଧାନ and ବିକ୍ରମ ନରେନ୍ଦ୍ର ସିଂ ଡୁଲି ପ୍ରଧାନ your lordship consider and the petitioner is Bikram and Surya not before your lordship kindly peruse the statement.
What statement?
It eyewitness ro ta poor
You have not been examined?
ନାଇଁ
Chinmay Parida.
ଗୋଟେ eyewitness examine ହେଇଛି. Specific କହିଲା lordship consider my lord
No.
Specific
He is the principal accused.
petitioner is not the
He is the principal accused. Bikram Narendra Singh.
See, same thing. Tapare not to vital the postmortem report.
That is a valid argument.
Yes, my lord.
That is a valid argument. But how about? Take now.
3 years is in custody.
जाओ किस दिन जाओ. This matter 1 week after.
नले किस दिन पे दियंतु आउ थर interim bail नले कि
ना. See, I go ये clear case murder case इतने.
ये your lordship visualize my lord.
वो पूरा visualize कर सकते. Experience का अच्छी.
Some days your lordship consider my lord.
Yes, Mr.
He is the principal accused leading to discovery that one of officers is from the
trial charge छाड़ दे लगा
trial ଟା stall ହେଇଛି କାହିଁକି ନା C report ଟା ଆସିନି ବୋଲି report ଗୋଟେ କଲଫର କରିଥିଲେ ସେଇ ଯୋଉ ବନ୍ଦ ହେଇକି ରହିଛି ଏଇ 10ଟା 12ଟା ଏକ୍ସାମ
report ସାରା କାଇଁ ବନ୍ଦ trial ବନ୍ଦ
କରି ତାପରେ ତ ଆଉ ହେଇନି. Consider for some days my lord.
Bully Pradhan is different footing, Bikram is different.
Interim bail ବି ଯାଇଥିଲା ଏ ଥରେ your lordship consider 1 month or 2 months, yes, rightly time re surrender.
হবনি হবনি এটা হবনি মানে হবনি ইয়ে হবনি
Then 1 week after.
1 week after yes the remaining matters I'll take up after
Item number 39.
I'll take up after recess.
After recess, I will not be there, but I'll take it up tomorrow. So that case, my lord, where the call for the report is not there. It is A and B.
আজি consider করা আজি যদি না হবে কালি হবে I've given sufficient opportunity.
Yes, yes,
You cannot say that no opportunity has been given.
No, no,
For more than a year, but more paper pending halani.
Yes, ma'am. A report was your lordship call for a report is there.
You are not available after recess?
This is data.
হ্যাঁ সেই
Kasabdi.
মানে এটা 39 ଅଛି ଆମର ଯାଇଛି 35 ଯାଏ କେତେ ଯାଏ 35 ସାଙ୍ଗେ ସାଙ୍ଗେ ପଡ଼ିଯିବ ଆପଣ 3-4ଟା now submits that the petitioner has surrendered to custody on 16/5/2024 after expiry of the period of interim bail. He seeks some time to file the surrender certificate. List this matter next week. Surrender certificate be filed in the meantime.
Item 37.
37.
Extension from the.
Oh, yeah, acha. ସେପଟକୁ ହାତରେ ବାଜିବ ନା ଏମିତି ଏକ୍ସଟେଣ୍ଡେଡ୍ ଟିଲ୍ ଜୁନ୍ ଯାଏ ସେ ମାଗିଥିଲେ all right time is extended till the end of June 2024 for disposal of the case.
Item 38.
May I please, your lordship?
Yes.
The petitioner has granted the interim bail, and now the petitioner wife is in a serious condition and shortage of sodium and potassium, and extension of
Yes, Mr. Pandey.
bail. Period of
Why were you appearing?
In support of the averment submitted by my learned friend, there is no such documentary evidences nor any such reports, etc. On last occasion, my lord, out of mercy, granted bail.
Not out of mercy. Not out of mercy.
All
no question of any mercy.
Number of eyewitnesses are there.
Mr. Paddy, there is no question of any mercy or any other emotion operating here. 45 to 21 witnesses ହେଇଗଲେଣି କେତେ ଦିନ ପାଇଁ ଯାଇଥିଲେ 4 weeks
4 weeks
2 weeks ବେଶୀ 2 weeks ଦିଆଯିବ ଆଉ କିଛି ନାହିଁ considering the submissions extended by 2 weeks it is made clear that no further extension shall be granted so surrender in time item 39 please this matter तापर वो डेट कर दो
8 जुलाई को थिला ଏବେ ରଖିବେ my lord
कर दो
published
Item 39.
39 your lordship call for a report. Fact case.
Before 18th June, copies of the deposition of the report ଦେଇଛନ୍ତି
Report at fact came.
yes non-service of summon to Mr. A&B due to shortage of staff yeah the high court no eta gote panchayat ho ମୋତେ ଲାଗୁଛି ମୁଁ I think I am a sarpanch presiding over a panchayat the government will write like this IAC says that because of shortage of staff I could not serve this
Playing game track.
anyway as the whereabouts of the summonee could not be ascertained learned additional sessions judge Bhavani Patna has submitted a report stating therein that the witnesses named Mr. A and Mr. B have not been examined, as the summons issued to them could not be served because of several reasons, including shortage of staff due to general elections in the police station.
Would you hear him?
The petitioner is in custody. I will grant you interim bail,
Valid.
not regular bail. I will grant you interim bail.
Since 8/3/2022.
The petitioner is in custody since 8/3/2022. Considering the seriousness of allegations prima facie leveled against the petitioner, this court was not inclined to grant bail to him. However, despite being in custody since then, trial has not concluded as yet.
Because of A and B. Because ballot may see on 10/6 also after election, case has been adjourned.
Has not been. As yet. Moreover, the identity of two important witnesses has been kept, has not been disclosed, and who are said to be whose evidence is said to be material to the prosecution case. Stop. The case record reveals that several opportunities have been granted to the prosecution to examine the said witnesses named Mr. A and Mr. B. Obviously, a person cannot be, however grave the allegations may be, a person cannot be detained in custody indefinitely without trial being concluded within a reasonable time. Under such circumstances, this court is inclined to take a lenient view in the matter. I will not dispose of the application. Let it depend. The Purbuti got a paragraph Mr. D.P. Dhawal and senior counsel appearing with Mr. A. Rai submits that the petitioner has been unduly harassed by being kept in custody indefinitely and indefinitely, while the prosecution has not taken prompt steps to expedite the trial. Sri S.K. Mishra, Land State Council, has opposed the therefore, the petitioner may at least be released on interim bail in order to attend to his personal needs and that of his family members. Sri S.K. Mishra, Land State Council, on the other hand, has opposed the prayer for interim bail by submitting that grave allegations have been leveled against the petitioner, for which no leniency should be shown to him. Having considered the rival submissions and on going through the case record, this court, taking note of the fact that sufficient opportunities have been granted to the prosecution to examine the witnesses named Mr. A and B, which it has failed to avail, this court is inclined to take a lenient view. In such view of the matter, let the petitioner be released on interim bail for a period of 4 weeks.
2 months. Nahanti Saman ballot may grant 4 weeks. I have no objection.
Extension of
ultimately, ballot, the heavy cost should be imposed on the person, the IO, who has given a closed envelope before ballot with regards to A and B. Because that weighed in the mind of the
No,
court. I also considered on that day.
No, no, you had considered, fair enough. I will not say that you very fairly, you had considered that, yes. But I'm saying 4 weeks. So this by itself is a.
Melody.
I would say the order by itself is
Melody fix up a date on instead of surrendering before the surrendering date, if if A and B would have been examined, Melody,
he has already fixed it to 22nd of June. This is what he has said. So I am granting you 4 weeks time. That is why I am granting you.
With regards to before the matter will be taken off here, whether the petitioner will surrender or beforehand, that I want.
ମୁଁ ବୁଝିପାରିଲିନି
22/6 ଯଦି ଟ୍ରାଏଲ ଫିକ୍ସ ଅଫ୍ ଅଛି ଏକ୍ସାମିନ ହେଇପାରିବନି କାହିଁକିନା ସମନ ଇସ୍ୟୁ ହେଇନି ଲୋକ କେହି ନାହାନ୍ତି. That too, I was talking with my learned friend also, SP, rank of SP is also IO. But he is raising his hand that the person is not available. My lord is granting bail for a period of 6 weeks.
4 weeks.
So 4 weeks. My lord, fix up a date. On the beforehand, my lord, it may be taken up, listed. So that.
Before fixing a date for what?
Fixing a date, my lord, here in the listing.
Listing of this matter? Yes, I will do.
Before completion of 4 weeks, my lord.
Yes, that I will do. If extension over the extension over, sorry. On such terms and conditions as the court below may deem fit and proper to impose, including the following conditions. 1, he has to appear.
My lord.
He shall appear before the IAC of court, Thana. Norla PS. On every Sunday at 10 AM, and such fact shall be certified by the IAC to the concerned court. Every week. He shall not leave the territorial jurisdiction of the court without obtaining leave.
Also before the trial court of the date fixed.
And he shall also appear. He shall personally appear before the trial court on the date of posting of the case without seeking representation through counsel. This is matter on 4 weeks. Just go.
15th July.
15 July. This is matter on 15 July. Yes, Mr. Mishra. I have given enough liberty to the prosecution.
I have also talked the STPO.
What you do? What?
PP, additional PP, everything I have talked.
Ground that his wife illness, my lord. Now, my lord, he is undergoing treatment, my lord. I pray for only
interim bail, considering the submissions. Interim bail granted by the order dated so is extended by a further period of 2 weeks.
4 weeks, man.
3 weeks. It is made clear that no further extension shall be granted. Yes.
Much obliged.
Item 41.
My lord, this is a case offense under section 458, 395, 25, 27 Arms Act. The present first item petitioner arrested on 27/8/2023, charge sheet submitted on 24 December 2023. During investigation, 8 persons arrested, and in the FIR it is mentioned that while the informant and his son were inside the house.
What is your name?
Hemant.
I have rejected the bail of a co-accused person.
Before the submission of
Raja and one other person.
Court below came before this honorable, therefore rejected. In this case, no TA period conducted. No TA period conducted. Recovery, almost all the money.
Open the case diary.
Case diary is there, my lord. During course of investigation, 1,68,50,000 has been recovered from all the accused persons. And individually, 30 lakhs, 30 lakhs.
Mr. Rocky, you are appealing for the informant?
No. I am for one of the accused. That is
connected matter.
Yes, Lordship. 431.
Similar putting 2 crores in the lordship rejected.
No antecedent, my lord.
No, Mr. Nak.
This petitioner moved the court below after submission of charge sheet. That bail application was
395 charge sheet पूर्वर किछि ये नहीं.
TA period नहीं, किछि material नहीं. Absolutely.
No, हवन.
ବର୍ଷେ ପାଖାପାଖି ରହିଲାଣି.
ये कैसे हवन? How many, Mr. Ratha?
Lordship, but my footing is different. I am the driver. I was being arrested from one of the co-accused house. The amount which is seized, the allegation that 10 lakhs is being seized.
Yeah. Havan.
I'm 19 years old.
Kichi Havan. Havan. Havan feel is done. You know this court. Havan.
Okay, then Rahul to.
Ravi कौन हबो मिस्टर नायक
My lord,
जुडिशियल कॉन्शियस परमिट करनी कौन करी आज कौन तो वर्षे पर ही करे जाओ 2-3 मास जाओ जति कहबो रही तो दिस मैटर 1 week after
42.
For extension of time on the ground of the health condition of the wife, she has been detected with dates.
ଆପଣ ସବୁ କେସ या पूर्व केस विषय
ଯାହା ଅଛି ନା ଆଉ ଆମେ
ସତ କଥା
ସତ କଥା
ହେଇଥିବ
ଆପଣ ଦେଖୁନାହାନ୍ତି 10 page 10
हम पेज 10 पर मार ऑर्डर देखे मैं ऑर्डर देखले मैं बुझी जी
हाँ 1 year more
ऑल राइट considering the submissions
my lord 2 months I need because surgery she needs a
the
surgery.
interim bail granted by tolerated so and so is extended by a further period of 6 weeks.
Oblige.
43. The receiver, my lord, of the property.
Yes.
Receiver of Dr. 412 the allegation against person. All co-accused persons. Some of the co-accused persons.
What is your name?
This
Sajan
Alia Sanjay Kumar Sahu.
Dhanadas reject hichi. No,
That's allowed, my lord.
And
Yesterday, yes, my lord. Yesterday also, your lordship allowed one of the. There is the receiver. They are the main actor.
No, you. How do you stand on the same footing with the
The same footing, better footing.
No. There can be no question of better footing.
No, my humble submission, the person who has allegedly committed the crime, I was not there. And subsequently, it is alleged that they have sold the property to me. 412 was more allegation.
Para 5 Lakuntu. Insofar as the petitioner is concerned, it is alleged that he is the receiver of the stolen property. There is no further allegation. There is no specific allegation that he was present at the spot at the relevant time. Bati jaaj hai na?
I not press.
आइए नोट पे सर्व कर दो.
Item 44.
कितने अच्छे हमारा टोटल इतने 48 कितना अच्छे ठीक है 44 yes
petition written for receipt 28/4/2022 in offense of 20B2C.
कौन नाम अपन करो
Sanya Chalan.
Sanya Chalan
Arrested from the spot and
Sanya Chalan आपको रिजेक्ट नहीं चाहिए
Lordship.
रिजेक्ट ही कौन करे जो
Yes, Lordship.
Sanya Chalan तो अपने इंटरन बेल भी निकला मासे
Currently, right time surrender Lordship.
मासे
Lordship, due to now delay of I have paper.
केबे टू वाले कस्टडी
Lord, sorry.
केबे टू कस्टडी वाले
22/4/2022. Your Lordship just recently judgment.
What is the कौन judgment
Sorry.
कौन judgment करना था ये
Ankur Chaudhary versus Stratton.
कौन क्वेश्चन से थे कौन क्वेश्चन करना था क्या
That
ये डिले ट्रायल है ना छोड़ो अब
that's a पहुंच आयोटा को आयो ना दे आयोटा को material witness आना दे
अच्छा
से ground तक release 2 years detention for
ये what is the status of the trial
out of 17 we received 3% of examined.
We have been examined.
Yes.
Shall we call for a report?
trial is going on, my lord. Huge quantity.
No, I have once granted him interim bail. I cannot grant him interim bail again. I will not grant him a regular bail. I will grant him interim bail. If he wants the regular bail, you go to Supreme Court.
Regular bail, Supreme Court.
No. अगर हमें interim bail दो.
You will see that
regular bail देवी नहीं. से कहीं साइड कोचिंग आएगा मैं तार 500 जजमेंट देगी तो को ये करेंगे डिस्टिंग्विश करेंगे अपन जीवे सुप्रीम कोर्ट जाए देखेंगे I am willing to grant you interim bail but let a report be
Yes, my lord.
First, let a report
thereafter.
What is the status?
Lordship kindly grant that order and that reflect that
no I will grant you that order, but thing is that I should know what is the status of the trial.
On my instruction, out of 17, 3% have examined.
All right.
Order
The petitioner is in custody since?
or 2022.
28/2022 in connection with such and such case. It is alleged that John is single.
Dijon.
The petitioner and another person were in possession of huge quantity of contraband ganja weighing
775 kg.
775 kgs
200 grams.
when they were apprehended by police. Learned Counsel Sri Nihar Ranjan Sahu, Sri N.R. Sahu, Learned Counsel for the petitioner submits on instructions that out of 17 charge sheet witnesses, only 3 have been examined. The petitioner has been detained for more than 2 years.
2 years, 1 month, 22 years.
2 years. He further submits, because of such long incarceration, certain problems have cropped up in the family, which require his personal attendance, personal attention. Learned State Counsel opposes the prayer for bail. He therefore submits that the petitioner may at least be released on interim bail for some period. Considering the submissions, the materials on record, and particularly taking note of the fact that trial is progressing slowly, and the petitioner has been in custody for more than 2 years, I am inclined to take a lenient view. The bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 2 months. Yes.
Item 45.
Obviously.
May I please, Lordship? My Lord, I am moving for interim bail, my Lord. The petitioner was earlier before this Hon'Ble Court in BLAPL number 180 of 2024. My Lord, please to grant bail him 1 month. In the meantime, the petitioner surrendered. After surrender, jail authority treating him at hospital. His surgery is scheduled to be fixed on 17/6, but due to some infection, it could not be possible. I humbly pray report may kindly be confirmed. After confirming report, post-surgery treatment care is necessary.
Sri P.S. Naik, Learned Counsel for the petitioner, submits that the petitioner was due to undergo surgery on 17/6/2024. Then because of certain infection, surgery could not take place. Then State Counsel shall obtain instructions with regard to the health condition of the petitioner. Is this matter next week? Oh, telephonically. Next week.
Item 46. 46, very on behalf of Viraja Prasad Nandam. Here in this case, my lord, just have filed one IA for the modification order dated 2/2/2024. That case, my lord, Lordship allow the bail application subject to condition that injury must be simple, my lord. But subsequently, my lord, injury found grievous.
The last sentence of paragraph 5 be deleted.
Item 40, my lord. The surrender date is, my lord, 22. That's in the course of the day, certified by, my lord.
Item 42.
40, my lord.
Item 40. In course of the day. Oh.
Item 47. Much obliged.
May I please, your Lordship, matters. Offense under section, my lord, 366 along with other allowed offenses, my lords. And your Lordship rejected the main bail application of the Niranjan Jena and allowed the other co-accused, namely Akshay Kumar Boral, my lords. Present petitioners not named in the affair, my lord. The affair allegation, my lords. Present Niranjan Jena along with 4 to 5 other persons kidnapped the victim girl, my lords. That is the allegation.
The victims, I had examined I had seen the victim's statement before rejecting the application.
Niranjana is
So
the
victim
main.
statement of the
ପାଖରେ ଆଜ୍ଞା ନାଇଁ କହିବ FIR ଟା ମାଇଲର।
ଦେଖିଦେବା ମଗେଇଦେବା
ଏଟା କେବଳ ଅଛି
ନାଇଁ ମଗେଇଦେବା
ମାଇଲର୍ସ।
And this present petition is not named, my lord.
Not named in the FIR, all right. But whether the victim has said anything about him, up to date case that we obtained, including the statement of the victim, list this matter. 4th July, no course of action be taken against him.
Item 48.
May I please, Anganwadi? I mean, in this case and a counter case, the alleged offence, my lord, 294, 307, 323, 324, 341, 354, 5034 IPC. In the meantime, except petition or all are religion bill, counter case in Madhya, some religion bill. Common ancestor houchin jane tankar di bhai. Informant and the cousin brother due to demarcation hatte join by disturbance.
Present petitioner's bail application already rejected.
Already certificate they just said that minor that is during investigations. Order honorable court karthale first or second or same day disposal of by the session judge. Say समय during investigation ଆମେ ଦି ଜଣ ପାଇଁ notice କରି ଦେଇଥିଲୁ because arrested and religion bail. ଆଉ ବର୍ତ୍ତମାନ ସିଏ କିନ୍ତୁ actually ସେ ନଥିଲା ବାହାରେ ରହୁଥିଲା ବର୍ତ୍ତମାନ changing circumstances charge sheet already submitted and all the accused person religion bail ମୋର counter FIR ମଧ୍ୟ ସମସ୍ତେ ଯାଇଛନ୍ତି.
Yes,
ये old
That
man.
instruction I don't have, my lord. But direct allegation is there of 307. He has assaulted my lord. Lordship see that.
Demarcation ହାତେ ଜଣ ପାଇଁ ଗଣ୍ଡଗୋଳ. No accident car nahi old man.
You report your lordship.
Sabara khanda issue kori Yes.
Grievous injury. Head grievous injury.
By perusing the case diary, lordship directed for first or second or manner.
तो first or second or नहीं जाऊँगा
ସେ
order ଥିଲା 2 weeks
ସମସ୍ତେ ଗଲେଣି ଇଏ ଗୋଟେ ପେସେଣ୍ଟ ଲୋକଟେ ମାନେ
नहीं समझ गए नहीं
ଆରେଷ୍ଟ ହେଇପାରିଲାନି ସେ ଥିଲେ ନା ତ ପୋଲିସ ଆକୁ ଆରେଷ୍ଟ କରି ଫରୱାର୍ଡ କରିଥାନ୍ତା ଏ 2 ଦିନ ରହି ବାହାରି ଯାଇଥାନ୍ତା
नहीं से first or second और कौन असुविधा होची
ଫାର୍ଷ୍ଟ ଅର୍ ସେକେଣ୍ଡ ସେମ୍ ଡେ ଡିସ୍ପୋଜାଲ ବାଇ ଦି ସେସନ ସେଟା ବି ହେଇଥିଲା ଆମର ପାରିଟି
ଟା କହିବନି you don't stand on the same
same my lord common allegation ଆମର ତାଙ୍କର ଯାହା allegation ଏଣ୍ଟାର my lord I did the FIR ଗୋଟେ common allegation
केस दा इंजरी रिपोर्ट आसु देखिया स्टेटमेंट वाला देखिया informant is appearing
Yes,
what do you say
Lord, out of 3 injured person, 2 injured person has sustained grievous in nature injury. My lord, I have the medical certificate also, my lord.
my lord
My lord.
assaulted
basis religion bill ମୁଁ ତ ନଥିଲି ସ୍ପଟ ରେ
Yes, your name is there.
My lord, there is a specific allegation about the present petitioner, my lord, Rasanand Samal.
FIR ଟା ବି ଦେଇନାହାନ୍ତି
ନାଇଁ ସଦାନନ୍ଦ ନାଁରେ ସ୍ପେସିଫିକ
Sadanand Samal and
ନାଇଁ ରସାନନ୍ଦ
ସଦାନନ୍ଦ ରସ ସମସ୍ତ ନାଁରେ ତ କମନ ଆଲିଗେସନ
no injury on vital parts
my lord
Sir, head injury ଅଛି, your lordship.
could
ସେଥିରେ
injury on right hand and
ଗୋଟେ ଆଙ୍ଗୁଳି ବି କଟିଛି।
ହଁ ଗୋଟେ ଆଙ୍ଗୁଳି ଖାଲି କରିଛି ଗୋଟେ ସମସ୍ତେ କାଟିନି ଏତେ ମୁଦଲା କେତେ ଜଣ
head ଅଛି hand ବଢିଆ ଦେଖା
ତାପରେ ଇଏ ବି ଇଞ୍ଜୋର୍ଡ ଲୋକ my lord ଇଏ କଣ ସ୍ପଟ ଥିଲା ନା ଇଏ କଣ ବାଡେଇ ପାରିବ କି ନା ମାରି ପାରିବ
କଣ କରିବା up to date case diary ବି obtained ଆମେ statement ଦେଖିକି ଦେବା list this matter on 4th July no course of action shall be taken against him
Pastor item number 57.
ଗୋଟେ ପାସ ହେଲା
27, my lord. Matter has come for condonation of delay, my lord.
Yes.
File IA number 716 of 2023.
Somebody has appeared.
My lord.
You have appeared.
My lord.
What do you have to say on the delay?
My lord, the delay may be condoned, my lord, subject to some cost.
कितने दिन delay?
17 days.
17 days delay की cost होगा? Office has pointed out delay of 13 days.
Okay.
I election है ना? Considering the grounds taken to explain the delay caused in filing of the second appeal, and upon hearing learned counsel for the appellant and the respondent, this court is inclined to take a lenient view. The IA is allowed. The delay in filing of the appeal is controlled. Place this appeal for admission next week. তারপরে
So item number 32.
Perhaps in this case, cause of action doesn't survive. In fact,
আমি শেয়ার করতে পারি নো নন অ্যাফেয়ার্স নো কজ অফ অ্যাকশন করে কি ইফ এনি কজ অফ অ্যাকশন সার্ভাইভস করি ডিসপোজ অফ করতেন ইয়েস দেখো এটা কম হয়ে গেল চলো তো সাপ্লিমেন্টারি না দেখো
Weekly list item number 20.
No, weekly list, there are two matters, 23 and 26. I'll try to take
23 and
27. Today, if I'll come, then I'll do it. Otherwise, tomorrow. If we finish the work and come, then.
পূর্ব যদি আমি উঠে যেতে ডিপেন্ডস অন মিস্টার দাস
No, no.
কালি
More surreal.
না আপনাଙ୍କ পার্টটা
More surgery boile sange sange.
না ଆପଣଙ୍କ ଅପୋଜ କିଏ କରୁଛନ୍ତି
କେହି କରୁନାହାନ୍ତି
ମୁଁ କେହି ନା
ଆକ୍ଟିଭେଟ୍ କରୁନାହାନ୍ତି
କାହିଁକି ନୋଟିସ୍ ଯାଇନି କି
ନାଇଁ ନୋଟିସ୍ ଯାଇଛି ବଟ୍
ମାନେ ଏକ୍ସପର୍ଟ
ଆଜ୍ଞା
let us hear it but if you are not there I will adjourn ମାନେ adjournment କଣ ପାସ୍ ଓଭର ତ ହେଇକି ରହିବ for the day tomorrow it is there in the list ଆଉ
ଆପଣଙ୍କୁ କାଲି ରହିବ
yes sir whether the children begotten through remarriage of widow are entitled to succeed to the property of the intestate. Whether the lower appellate court is justified in holding that finding of issue numbers. Yes, sir.
There are two schedule B, schedule C in the plaint.
Yeah, but who are you are the plaintiff?
Yes. In a suit for partition, schedule B, that property was stated to be the ancestral property. The other item was stated to be the property which was in the name of one widow. So far as that is concerned, the trial court observed that this is not liable for partition.
Before that, you are the plaintiff. You filed a suit for partition.
Yes.
Who are the defendants? जो 14 ना 15 जन अछंती 16 जन defendants. Who are they? All co-sharers.
All from common ancestor.
The co-sharers.
Yes.
All right. So this suit was dismissed.
The suit was decreed.
Decreed. Then
suit was decreed so far as this one part of the property.
Yes.
Holding that it's an ancestral property. The other one was found to be the property of a widow. Since it is her exclusive property, the trial court said that it is not liable to be partition. Then an appeal was carried by, not by me, by
one of the co-sharers,
one of the defendant. There is no independent appeal or cross-examination by cross-objection by the plaintiff. So far as the refusal of the relief of partition in respect of one of the schedule, for which order 41 rule 33, that is one of this. And so far as the property which was directed to be or partition, that was held to be the property of the joint family, where one widow was there. Then the question came, she had remarried and her children, whether they will be entitled to share, that became the question. When a trial court said that she is not entitled to it because of her remarriage. Accordingly, the learned trial court proceeded, but that finding of the learned trial court was reversed by the learned first appellate court, and then came to the conclusion that the heirs of the widow will be all necessary parties to the suit, and hence that property, that the other one was not challenged by that person, and then what it remains, because of non-gender of necessary party, ultimately the suit was dismissed. So now the question before my lord is the two substantial question of law, whether by remarriage the children which those who are there, my lord, if I read it, the substantial question of law.
Yes. Whether the children begotten through remarriage of widow are entitled to succeed to the property of the intestate.
That is, your lordship may kindly, I have filed a
Yes.
notes of submission.
Yes.
In fact, this starts at page 17.
Page 17 of your note.
Yes, my lord. Up to page 17, I have only quoted the relevant portions from out of the appellate court judgment, trial court judgment.
Yes.
So that it will be convenient to go through that.
So do we have the LCR? Nicola? LCR ଅଛି ତ? Physical ଅଛି ତ? ହଁ, ଠିକ, ଠିକ. Nobody has appeared, Mr. Das, let me just, for a moment, let me check up. କାଲି କି appeal ନ କରିବେ ପୁଣି? SR of appeal notice on respondent number 1 received personally wala. Okay, but there are many respondents. What happened to the notice?
The respondent number 1 was really aggrieved, who preferred the appeal and who had only contested the matter in both the courts.
No, likely issue notice to respondent number 1 only at this stage. Okay.
Maybe that is the reason.
Yes.
That defendant number 10
is the respondent number 1.
1.
So he was the contesting party probably.
He was contesting both in the trial court as well as in the
partition suit also, even if they do not appear, but they are,
can be done.
It can be done.
And only probably for that reason, this honorable court directed notice to the contesting party alone.
Yes.
He has not chosen to appear, but
how would you, assess the court in, can we decide to dispose of the matter without the presence of the other?
If they don't choose to appear, your lordship.
No, but notice has never been issued, na? Keval respondent 1 ko issue hoichi notice. He has not appeared. And it is a personal service hoichi. He has not appeared, so we will proceed. What about the other respondents? Notice has never been thought to be issued also.
That's right.
So what is to be done in that case? How can you advise the court in this regard? But I don't want any technical hindrance to be there.
That's right, my lord. They never choose to appear.
We will do one thing. Let us hear
in any of the courts. Neither they were there in the trial court nor in the.
No, I will do one thing. I will hear you. And before proceeding for judgment, if at all, I will give a finding whether notice is required to be given to them or not.
If ultimately the appeal is dismissed,
no, it has got no, it will have no
purpose. If your lordship is satisfied about the merit of the case or for some reason notice is necessary, because all that what I humbly will say, that this may be a case for remand. Because if your lordship will first of all hold that by virtue of order 41 rule 33, it was primarily the duty of the court to look into the other issue because it's a suit for partition.
Everything
because the objection is not filed or appeal is not filed, so no one should be penalized for it. Because rule 22, rule 33, both are both should go simultaneously together.
Well, all aspects can also be looked into.
Yes, my lord. That is the judgment of the apex court which I have quoted, my lord, in this note.
Okay, let us continue for some time. Let us continue and let us see.
And the other aspect is more vital, that your lordship will find the question. I just want to take little further. Whether the children begotten through remarriage of widow are entitled to succeed the property of the intestate. Now your lordship may kindly see, just below I have indicated.
Yes.
So far as the first question is concerned, it may probably mean and include as to if Golapo, that widow, herself who remarried before succession opened, and or her children through such remarriage are entitled to any share in the property of her former husband. Just I have put it in a different way. That I just added one thing, that if Golapo herself who remarried before succession opened, because what I intend to put before my lord, that if the widow doesn't get,
then the question of legal heirs getting
children, the next thing will never come. Then, my lord, your lordship sees that undisputedly the suit concerns the share in the property of HUF and is not about the right of inheritance in respect of the property of her deceased husband. If the succession reopens as soon as the husband dies, then the property will devolve on the widow, and whatever is vested with her, even if she remarries.
But you have said that she remarried prior to opening of the succession.
Yes, my lord.
So that has different meaning altogether.
That has some bearing in this
Yes,
case.
absolutely.
Because if it is the property of the husband, my lord, husband dies, property will go to the widow. Even if the widow remarries, property will not be divested from her. She will be the owner of the property. But if it is HUF property, and in the event the husband dies, then she is not getting the share immediately. A suit for partition is filed because on each day it varies. Succession opens otherwise, and that is probably the reason for which your lordship will find appropriately the language is from Section 24 of the Hindu Succession Act. That has not been taken into account by either the trial court or by the learned first appellate court. They have gone to proceed by looking at Section 15(2)(b). That is the only thing on which interpretation was given by the learned first appellate court. But if I stick to the language of Section 24, your lordship will find that there the word is not limited by the use of the word widow. There it is said that widow of a predeceased son, widow of a predeceased son's predeceased son, they will be debarred if they remarry. Very consciously, the words that has been used in Section 24 of the Hindu Succession Act 1956 omits the word widow, uses the word predeceased son's widow, predeceased son's widows, predeceased son's widows, predeceased son, double is there. By referring to probably the ancestral property, division of the ancestral property or the property of the HUF. Here, what has happened, the property was of one Sunna Behra. He had two sons. Then out of the two sons, in one branch, there are two sons.
Have you prepared a genealogy?
Yes, my lord, I have given the genealogy in the note of submission itself. At page 2 probably.
Sunna Behra, Govinda Panchu.
Yes, my lord. Govinda, not here your lordship sees Narottama Nottavara.
See Govinda Puo.
Then Golapa. Govinda branch.
See Nottavara wife.
My lord. Golapa Siala picture. As what I have said in my notes, your lordship may then kindly come to page 17. Page 17, your lordship may come to the next I have quoted in a very short manner. However, it being apparent that the husband of the widow has died before Section 24 of the Hindu Succession Act 1956 stood omitted by the Hindu Succession Act 2005, it may be significant to draw the kind attention of this Honorable Court to the provisions contained in Section 24 of the Hindu Succession Act 1956. Since Golapa remarried before the succession opened, in as much as the property was held in HUF. Here, one thing is conspicuous, that Section 24 has already been deleted by the amendment which came into force in 9/9/2005.
Yes.
This is a suit, my lord. And the appeal is also of 2003. The suit was much earlier and
before the amendment.
Before the amendment. And Section 24, my lord, I have quoted, my lord, your lordship may kindly see first of all. Any heir, first of all, the wording is any heir,
yes,
who is related to an intestate as the widow of a predeceased son, the widow of a predeceased son of a predeceased son, or the widow of a brother shall not be entitled to succeed to the property of intestate as such widow, if on the date the succession opens, she has remarried. So far as that the question whether succession opens on what day, Lord, in this regard, I have also got 2006-8 SCC 581. Apex Court held that the Hindu Succession Amendment Act 2005 does not apply to those cases where succession opened earlier. But then, since Hindu Succession Act 1956 as it stood prior amendment applies proprietary in as much as the suit for partition is in respect of the common ancestor and that the Golapo is related to the common ancestor as the widow of a predeceased son of a predeceased son. Thus, deceased Golap not being entitled to any share in the plain Schedule B property, her children begotten through subsequent remarriage are not entitled to succeed to the property of the intestate. As such, the findings rendered by the learned First Appellate Court cannot be sustained, and the first question is to be answered in favor of the appellate.
So this effect of section 24 has not been considered by the trial court?
Yes, my lord. By the learned First Appellate Court.
Okay.
And your lordship may kindly see that the finding of the learned trial court was that Golap is not entitled or the children are not necessary parties. How Schedule B was not for Golapo or her children. The property that was sought to be divided. And this is not challenged by anybody. Then what will be its effect, that your lordship? Then, my lord, I have come to the next question that was relating to issue number 6, the other item in the suit property which belonged to Golapo. It was pleaded by the plaintiff that it was acquired out of joint family. One property was purchased in the name of the Golapo, though it is there. The learned trial court, maybe I'll say that rightly, drew the presumption only that if the property stands in the name of a female member, it shall be treated as such until the contrary is proved. That is the appreciation of matter. But when it came to be challenged, then the question of analysis will be there that whether that has been rebutted or not rebutted, whether that finding of fact is correct or not. That has to be independently assessed by the learned First Appellate Court instead of ignoring. Whether that finding is correct or not, that was for the learned First Appellate Court, not at this stage, because that is a court which is the final fact-finding court. If certain evidence was laid on the basis of which the facts could have been determined, and it has been determined by the learned trial court which is assailed, the only hurdle was that no independent appeal was there, no cross objection was there. But there the Apex Court, my lord, has said in 1988 Supreme Court 54, which I have quoted, the appellate court could exercise the power under Rule 33 even if the appeal is only against a part of the decree of lower court. The appellate court could exercise that power in favor of all or any of the respondents, although such respondent may not have filed any appeal or objection.
Yes.
The sweep of the power under Rule 33 is wide enough to determine any question, not only between the appellant and respondent, but also between the respondent and co-respondents. The appellate court could pass any decree or order which ought to have been passed in the circumstance of the case. The appellate court could also pass such other decree or order as the case may require. The words "as the case may require" used in Rule 33 of Order 41 have been put in wide terms to enable the appellate court to pass any order or decree to meet the ends of justice. So if there were two issues only on which the parties were at variance, issue number 5 and issue number 6, the learned appellate court, my lord, with respect, confined the appeal only to issue number 5, and so far as issue number 6 is concerned, didn't touch it by saying that there is no appeal, no cross appeal. So it has attained finality. Finality will be attached to something after applying the judicial mind. By ignoring a contention, no finality can be said to have been arrived. More so when it was argued, because it shows that it was argued. But the learned appellate court.
But is it open to you to raise this point when, particularly when you have not filed any cross objection?
That is my whole submission is that I can always take resort to order 41 rule 33, because I might not have challenged it by way of independent appeal or objection. That is what the apex court said. But if I argue when the entire matter is before the court.
No, this apex court judgment is on the power of the court under 4133.
My lord.
But
discretionary also.
No, discretionary. But here this court would like to be satisfied about the locus or the maintainability of such a plea to be being taken by a person who has not.
Apart from the satisfaction of the court that it is likely to affect interest of justice, because as a whole, if suppose the other party would not have preferred any appeal, then it would have been done finally by the judgment of the trial court itself, because that finding is against me and I have not preferred an appeal. But once the matter is open, that is why the Supreme Court said that even if it is against a part of the decree also, the court can travel beyond it. And if the whole matter is before the court, then what would be in the interest of justice in a suit for partition, whether to ignore a part of the property which is subject matter of the suit or to analyze the entire matter. The question is very small that could have been analyzed by putting the technicalities into picture. If the main thing is avoided, that was contended before the appellate court that yes, this is also liable to partition. Whether it is liable to partition or not, that could have been answered.
The question is, you never challenged it. Now
that's true, Milo. That is, I never challenged it. I never even raised a cross objection to the finding.
Now at this,
and I am trying to take resort to order 41 rule 33.
Whether it is open to you. That is what I would like to be satisfied.
My lord, I only simply say that if it is duty is on the court, it is probably the language what is always understood, that it is very respectfully couched if it is used for the court.
No, as you yourself said, Mr.
It is also said that as the case may require.
No, what I am saying is, supposing, as you have yourself said, no appeal would have been preferred. Then the matter would have attained finality because you have not filed any appeal.
My lord, my humble submission is that that's final if not challenged by either of the parties. If any of the parties intend to challenge, then the whole matter is opened.
All right. So your argument is on this aspect. All right. Now at this stage, supposing the court accepts your contention, then probably it has to be remanded.
Yes, my lord. That's it. That may be the.
Under such circumstances, notice need not be issued to the other respondent.
No.
That is why probably the court, while issuing notice, that was way back in 2004, decided to issue notice only to respondent number 1.
Yes.
Now, who's appearing for respondent number? Nobody has.
Nobody, despite notice, has appeared.
Well, let us examine it. Let's close it.
Hello.
The factual aspect to kichi nahi ho?
How kichi nahi?
The factual aspect to kichi.
Purely point of view, nothing.
All right. Hearing concluded. Order is out. How short? Anybody who is available? Yes, Mr. Honda. The other side কি আছে? অপশন শুনে কেতে আইটেম কেতে?
So weekly item 30 may be adjourned to some other.
This is 30, item 30.
No, more, I'm 26.
Tell wait. এটা কেতে গলা? Item 20 গলা না? 21 টো রাখলি? 21 টা? কাহার 21 টা? 21 কি অপশন? Item 21? 22?
22 জন item 23 তো 23 26
All right. Then let us begin.
ମୁଁ ଲାଷ୍ଟ ତ ନୋଟ୍ସ ସବମିଶନ with judgments ଦେଇଛି ସେଟା ଟିକେ ହଜୁର ଦେଖ
Yours is item 30 ତ?
26 sir.
26.
ଆରେ ସେ 364/18.
Oh, this is a pattern matter.
ଆଜ୍ଞା.
Oh, that report of the subcollector somebody.
ସେଥିରେ ଅଛି ରିପୋର୍ଟ ବଟ୍ ଏଟା ହଉଛି କ୍ଲାସ 2 ଏୟାର ହିସାବରେ ମୁଁ ପ୍ରଫିଟ୍ ଇଏ କରୁନି ସେଥିରେ if your honor will have a glance at the genealogy it will be very clear your honor.
କୋଉଥିରେ ଅଛି?
ମୁଁ ନୋଟ୍ସ ଅଫ ସବମିଶନ ଟା ଦେଇଛି ଫାଷ୍ଟ
ଦଉନ ନୋଟ୍ସ ଅଫ ସବମିଶନ ଟା
ଏଇଟା ଗୋଟେ ଏମିତି ଫ୍ଲାଗ ମାରିକି ଦେଇଛି ଭାଇନା ଅଛନ୍ତି କହୁଛନ୍ତି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଅଛନ୍ତି ନା ଫାଇଲ ନାହିଁ ଆଉ ଗୋଟେ ଦିନ
Let me find out the tomorrow your lordship may call me.
କାଲି ଟିକେ ଫାଷ୍ଟ ହାଫ୍ ଟିକେ ମୁଁ ପ୍ରୋବ୍ଲେମ
First half ତ ପଡ଼ିବନି second half ରେ ପଡ଼ିବ
ହଁ ସେକେଣ୍ଡ ହାଫ୍
we'll just pass it over.
Last call it next minute. Weekly ଆସିବ ଏନିକେ ମୁଁ ଅଛି ମୋ ଅଛି
ମାନେ ମେନ୍ କଣ୍ଡିସନ ରେ ସାର୍ ରହୁ ଆର ମୋର କିଛି ନାହିଁ କିନ୍ତୁ ଯୋଉ ଫାଷ୍ଟ ୱିକଲି ଲିଷ୍ଟ ରହିଲେ ଭଲ ହୁଅନ୍ତା
weekly list one
ମାନେ ମଣ୍ଡେ ଯୋଉ ଦିନ ଆସୁଛି ଦିଟା ଲିଷ୍ଟ ଗୋଟେ ରେଗୁଲାର ତାପରେ ସେଟା ଆମର ଯଦି ପାଠଟା ଫାଷ୍ଟ ଲିଷ୍ଟରେ ପଳେଇ ଆସିଲେ ସରିଯାନ୍ତା ମାନେ ସେ ମଣ୍ଡେ ଦିନ ପଡିଯିବ
ରହିଯାଉଛି ତ ସେଥିପାଇଁ
ଯେମିତି
very difficult to address different kinds of matters. ଗୋଟେ type of matter ହେଇଥିଲା ଆଉ ଅସୁବିଧା ହେଇନଥିଲା
ସାର୍ ଯେମିତି
ଆଉ କଣ ରହିଲା? Item?
So item number 29 ଏଟା next week ରହିବ sir
Next week.
ଆଜ୍ଞା
29 my lord, I have taken consent of the respondent man. The lordship may call this matter 4 weeks after. Mr. Ashok Das has undergone operation my lord.
Item এটা কেতে ହେଲା 29 ତ?
29.
A request for adjournment is made on behalf of the counsel for the petitioner on the ground of his personal the appellant on the ground of his personal illness. List this matter in the week commencing 8th July.
Yes, sir.
item number 30
Lordship, I'm for the appellant. We need some more time for preparation. May this item be adjourned to some other day.
How much time do you want?
2 weeks.
commencing 8th July
This is matter on week commencing 8th July as per for. ତିନିଟା ରହିଲା କଣ ଖାଲି କାଲିକି ରହିଲା ରହିଲା କାଲିକି ରହିଲା
Sir.